Ah, yo vi así. ओके पार्सल में जाना होगा मेरा पार्सल मेरा पार्सल देखा उसको देखा कि नहीं Only three of us. Important breach force education multi-grading skill trained teachers are there who take down the IQ skills of the student and for 8 months skill after completing that they are okay. They mainstream to the nearest. They are admitted in municipal school. कैमरे के साथ थोड़ा ध्यान रखो हाँ ये 6 years ओरिजिनली फ्लैग ऑफ મારા આવો એટલે વાંધો નહીં આગળ દઈને લઈ લો એટલું તો ટેન્શન થઈ જાય હા હું એક્સપ્લેન પેલે બાજુ હા વાંધો નહીં ને કેવળ Second, we are losses, justice the pattern, and he also 139 feet said point of time for us. Then multiple activities have been carried out. One creative is to be she came and stayed with me, and she was seriously trying to the signal के बच्चों के साथ थोड़ा वो लोग यार अरे आप आइए आप लोग आइए सेंटर पाछा हो जाओ वाइट में सेंटर आ जाओ साइड में आओ वाइट में सर 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 अंदर आइए बारह को नहीं लाओ बारह मैम 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 क्या नाम है आपका बेटा
हम लोग फिर सा बाजू करो।
अच्छा उठा लोगे हैं? अभी मिल जाएगा। सामने देखो, इधर देखो, छोड़ दो उसको, ठीक है।
चालू नहीं कोई।
क्या नाम है आपका? हाँ, इधर घूमो, इधर कैमरे की तरफ देखो। हाँ, इसको पकड़ो। ऐसे खड़ा है ये तो। हाँ, वेरी गुड। अभी मिल जाएगा बाद में।
मैडम आया था तुमने सारू लेते
बस
हाँ बस
अभी आप
क्या नाम है आपका?
यस करो
लक्ष्य।
हाँ अभी तो आप
उधर घुमाइए
तो बेटा बच्चे आवाज
पानी तो उसी में लग रहा
पहले चाहिए मिलेगा, सबको भी मिलेगा।
इधर आपको बहुत तेज खड़ा होना सर ये इनका कितने 140 बच्चे ये just lack of क्या ये भी जैसे एग्जाम आते हैं चलानी है तुम चला लो Lordship has in fact has no belief of that sort of community on the board but something
देखो
बैठना भैया कर બધા આ બાજુ આવી જજો
હા
લાંબુ કરજો ને તમારું
આવા દો બહાર આવા દો
पीछे 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 आ जाओ पीछे So much. Good. Go. आपने प्रॉमिस किया था कि आप उसी आएंगे 1 अगस्त को आप आए नहीं 2021 में आपने क्या बनाया था उन्होंने आपने प्रॉमिस किया था कि आप 14 दिन चलेंगे नहीं आए
और पाछा आवजो वाइट नहीं મળે પછી વાઈટ લેવાની વાઈટ લે હા વાઈટ ફોટો કઈ છે આગળ આવ્યો રૂ ટેપો લેતે વાઈટ લેવાની જલ્દી ફટાફટ લેતે
थोड़ा पाछड़ आई जाओ थोड़ा पाछड़ आई जाओ बेटा थोड़ा पाछड़ आई जाओ
હા
चलो वाइड आई जाओ
Wide आई
फोटो
जाओ।
पाड़वानो चलो
હા અમૃત લેતે ફટાફટ
चलो पाछड़ आई जाओ चलो हजू पाछड़ आई जाओ कैमरामैन
હા ભાઈ સાઈડ માં
थोड़ा पाछड़ आओ नहीं थोड़ा पाछड़ आओ थोड़ा पाछड़ आओ चलो चलो पाछड़ आओ
and vigilance. Administration and inspection implements. So Jacob Gawar in charge of arbitration center. Is Prashant है registrar law legal inquiry recruitment. Their academy
Very good morning. In a very short span of time, the distinguished dignitaries would be arriving and we'll be commencing the inaugural session in a very short time. Apart from today's this inaugural session of a conference, Gujarat State Legal Service Authority has launched one unique initiative as part of expansion of its existing project of Signal School, whereby the kids below 6 years now are also imparted the education through mobile school. The Ahmedabad Municipal Corporation, Ahmedabad Municipal School Board, and GSLSA jointly has initiated this vulnerable section of the society whose kids are not provided this facility of education has been provided this accord. Honorable Mr. Justice Vikram Nath, Judge Supreme Court of India, has inaugurated the project. And soon, very soon, we'll be having inauguration of, again, a great initiative, a combined initiative by Gujarat High Court Arbitration Center, Gujarat State Judicial Academy, and Gujarat State Legal Service Authority, whereby we'll be having a 2-day conference on mediation, a tool for dispute resolution for commercial disputes and arbitration. So a great initiatives by all three institutions of High Court of Gujarat. Of course, best August House. It's the composition that has the presence of former Honorable Supreme Court judges, Honorable judges of High Court, former Chief Justices of various High Courts, former judges of our High Court, district judiciary judges, advocates of High Court, advocates representing all throughout the state, mediators of High Court Mediation Center, mediators coming from various parts, in fact, from talukas also, and most importantly, students also. So it's a composite matrix that is there present in the August House to witness this great event. We are expected in a fractions of seconds presence of our distinguished dignitaries to grace the occasion. Friends, we are having the presence of our distinguished dignitaries. May I request to give a big round of applause for our distinguished dignitaries, legal luminaries who are going to grace today's gala event. Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India. Honorable Mrs. Justice Sunita Agarwal, Chief Justice, High Court of Gujarat. Honorable Mr. Justice Biren Vaishnav, Judge, High Court of Gujarat and Executive Chairman, Gujarat State Legal Service Authority. Honorable Mr. Justice A.Y. Kokje, Judge, High Court of Gujarat and President, Gujarat State Judicial Academy. This be a great event, a holistic event, an event which actually has a matrix of all the stakeholders to deliberate one of the contemporary and most important subject, inform as an ADR tool of mediation, how effective the same could be for resolution of dispute of commercial nature or the arbitration that is going to be deliberated. We'll be having the best of speakers, we'll be having the best of panelists to make out. But first, this inaugural session, we are having the legal luminaries with us. May I request Learned Registrar General to escort the distinguished dignitaries, Honorable Mr. Justice Vikram Nath, Judge Supreme Court of India, Honorable Mrs. Justice Sunita Agarwal, Chief Justice, High Court of Gujarat, Honorable Mr. Justice Biren Vaishnav, Judge, High Court of Gujarat and Executive Chairman, Gujarat State Legal Service Authority, and Honorable Mr. Justice A.Y. Kokje, Judge, High Court of Gujarat and President, Gujarat State Judicial Academy. May I request all present in the house to give a big round of applause for our distinguished dignitaries who are going to grace this event. With permission of chair, may I commence the proceedings? Namaskar, good morning to all. Galaxy of legal luminaries adorning the dais. Today's esteemed chief guest, Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India. Honorable Mrs. Justice Sunita Agarwal, Chief Justice, High Court of Gujarat. Honorable Mr. Justice Biren Vaishnav, Judge, High Court of Gujarat and Executive Chairman, GSLSA. Honorable Mr. Justice A.Y. Kokche, Judge, High Court of Gujarat and President, GSJ. Honorable Judges of High Court of Gujarat, former Judges of Honorable Supreme Court of India, former Judges of Honorable High Court of Gujarat, Learned Advocate General, Learned Additional Advocate General, President and other office bearers of Gujarat High Court Bar Association, members of Registry, respected Principal District Judges, judicial officers of the state of Gujarat, participating advocates, mediators coming from all parts of the state, dear law students, media personals, ladies and gentlemen. On behalf of Honorable the Chief Justice, High Court of Gujarat, Gujarat State Legal Service Authority, Gujarat State Judicial Academy, and Gujarat High Court Arbitration Center, I welcome all of you in this inaugural session of conference on mediation, a tool for arbitration in commercial courts. My limited memory fails to recount any such huge event taking place in past, wherein all the stakeholders coming from all corners of the state represented to deliberate the most significant subject on contemporary justice delivery system, that is exploring the concept of mediation in the commercial dispute and arbitration. The journey shall start with this inaugural session and with our tradition it shall start with lighting of lamp. Tamso ma jyotirgamaya. In the words of Gautam Buddha, and I quote, if you light a lamp for somebody, it will also brighten your path, unquote. May I request all the dais dignitaries to come forward for lighting of lamp. Moving ahead, Martin Luther King Jr. has rightly said, and I quote, a genuine leader is not a searcher for consensus, but a molder of consensus. High Court of Gujarat is blessed to have the visionary leader, Honorable Mrs. Justice Sunita Agarwal, a distinguished legal luminary, an able administrator, kind-hearted person with a compassionate approach, which are reflected in the multifaceted personality of Honorable Ladyship. Institutional development is the motto her Ladyship believes. It is in this count only that series of innovative measures have been taken to strengthen the system, be it rationalization of district judiciary, controlling the pendency of cases at high court and district level, improving the infrastructural facilities in state, and most importantly, updating the ADR mechanism in the state. We are indeed privileged to have the omnipresence of Honorable the Ladyship. May I request Honorable the Ladyship to make a welcome address.
Namaskar. It is indeed my proud privilege to welcome Honorable Justice Vikram Nath, Judge, Supreme Court of India, the chief guest of the 2 days conference on mediation, a tool for arbitration in commercial courts, an integrative approach to resolve commercial disputes. I extend my cordial and affectionate welcome to Brother Justice Viren Vaishnav, Executive Chairperson, Gujarat State Legal Services Authority, and Justice A.Y. Kokje, President, Gujarat State Judicial Academy, and all my brother and sister judges of the High Court of Gujarat. My special welcome to the distinguished former judges of the Supreme Court, former Chief Justices of different High Courts, and former judges of the High Court of Gujarat, who are making valuable contributions to the growth of the Gujarat High Court Arbitration Center. I am indebted by the presence of all of you. I will welcome Learned Advocate General Shri Kamal Trivedi, Learned Additional Advocate Generals Ms. Manisha Lavkumar and Mr. Mitesh Amin, and Learned Senior Advocates and Advocates of the High Court for extending support to the program by their presence. My welcome to Mr. I suppose he's not there. My special welcome to resource persons, Mr. Tariq Khan, Registrar, International Arbitration and Mediation Center, Hyderabad, and Mr. A.J. Jawar, a senior mediator, trainer, and arbitrator. Participant judges, advocates, mediators from all over the state, research and law assistants, law students, media personnel, ladies and gentlemen. We are truly blessed to have His Lordship, Honorable Mr. Justice Vikram Nath, in our midst today. As a distinguished member of the judiciary, His Lordship's wisdom, integrity, and dedication to the cause of justice serves as a beacon of inspiration for us all. Today is a very special day for me personally. I am privileged and delighted to welcome my old-time senior, mentor, and trusted friend, Justice Vikram Nath, in his Lordship's Karambhumi as his successor. Justice Vikram Nath needs no introduction in the Gujarat High Court. His Lordship has been the most dynamic and loved by all Chief Justice of the High Court. Though I joined the office of the Chief Justice after almost 2 years of His Lordship's elevation to the Supreme Court, but when I came, the name of Justice Vikram Nath was fresh in everyone's mind here. Almost every person, be a judge, a member of the registry, senior or a junior advocate who met me, referred to Justice Vikram Nath in the highest sense of regard and love. This is one remarkable feat not easy to achieve. You can see this feeling on everyone's face even today in this auditorium. His Lordship has set very high standards of the office of the Chief Justice, which could still not be touched by me. For the young ones who have joined this court after Justice Vikram Nath had left, I may introduce His Lordship formally. Justice Vikram Nath was elevated as additional judge of the Allahabad High Court on 24th September 2004 and took oath as the judge of the Allahabad High Court on permanent judge of the Allahabad High Court on 27th February 2006. His Lordship was elevated as the Chief Justice of the Gujarat High Court on 10th September 2019 and then as a judge of the Supreme Court of India on 31st August 2021. I may tell them that as an able administrator, Justice Vikram Nath, who keeps his cool in any complex situation, has smoothly sailed through the toughest of the time during COVID-19 for the Indian judiciary. Most of His Lordship's tenure in this court was passed during the COVID times, but under his dynamic leadership, not only the functioning of the court proceedings, both in the High Court and the District Court, was smooth, but many new initiatives taken were ensured. His Lordships achieved the distinction of being the first Chief Justice of a High Court in India to live stream the court proceedings of his own court on YouTube channel. Apart from pioneering the implementation of live streaming of court proceedings of the High Court of Gujarat, as a chairperson of Information and Communication Technology Committee of the High Court, His Lordship played pivotal roles in implementation of many of the innovative and path-breaking ICT initiatives by the High Court of Gujarat. Under his inspiring and dynamic leadership, the wheels of justice in the High Court of Gujarat continue turning with efficient and meticulous use of video conferencing, email filing, and e-filing of cases. A user-friendly online mentioning platform also came to be introduced. Email updates started to send information to the learned advocates for each and every event of the cases, including the progress of the matter in central filing center and caveat matching, if any, while also transmitting automatic updates of progress of certified copy applications. Digitally signed e-writs were transmitted to the jails for orders of bail applications in the High Court. Email my case status opened the doors for litigants and public in general to get email updates of any of the cases, also facilitating case updates to jail inmates while enabling them watching of the live streaming of hearing of criminal appeals from the concerned jails and e-filing of bail, parole, furlough applications from jails. Paperless e-Seva Kendra with EMCS facilitation was also established in the campus of the High Court of Gujarat. As a unique initiative, automatic email updates are sent to all the judicial officers of the state of the orders and judgments passed by the High Court, considering their orders and judgments. This is one of the very sought after and well received e-service amongst the judicial officers of the state. I'm informed that under the out-of-box visionary approach of His Lordship, the High Court of Gujarat became the first High Court in the country to start a telegram channel for providing causeless notices, etc., to learned advocates and the public at large. I sincerely thank His Lordship for wholeheartedly supporting us in this initiative. We eagerly anticipate His Lordship's insights and guidance as we delve into the crucial issues and challenges confronting our legal institution today. Disputes are inevitable in commercial transactions, and this gets further complicated with the party choosing to go in for litigation due to the inherent delays and cost of the process. As an alternative method of dispute resolution, the parties in commercial relationship invariably choose arbitration. However, it is observed that despite the fact that the arbitration as one of the modes of alternative dispute resolution contemplates minimal intervention of the court, seldom one finds the dispute referred to arbitration has not traveled to the High Court and the Supreme Court. In the ever-evolving world of alternative method of dispute settlement, need to incorporate the process of mediation in the form of conciliation in the arbitration proceedings becomes imperative. To overcome the delays and cost in arbitration, Med-Arb have been evolved as new methods for resolution of commercial disputes during the course of arbitration proceedings. The Gujarat High Court Arbitration Center for Domestic and International Arbitration has been established on 21st February 2021 in the stewardship of Justice Vikram Nath as the Chief Justice of this court. It was established with the vision of providing cost-effective and timely resolution of dispute. It is a neutral, non-profit venture dedicated to facilitate impartial and efficient administration of institutional arbitration proceedings. Highly skilled and experienced empaneled arbitrators with their extensive legal knowledge have dealt with 259 institutional arbitration, out of which the center has successfully disposed of 81 cases so far. However, there are small businessmen and petty claims where institutional arbitration may not be cost effective. There are big claims and big businessmen, but time taken in the arbitration proceedings may not serve their interest in the best possible way. In order to incorporate the concept of MEDAB and MEDAB into the arbitration process, an institutionalized system of mediation in the form of conciliation is to be established in the arbitration center, wherein professionally trained mediators attempt to mediate between the parties who are referred to the arbitration center. To my mind, if this collaborative process is adopted, there are chances that many disputes may be resolved at the inception itself. I'm happy to inform you that the Board of Governors of the Arbitration Center, under the leadership of Justice Biren Vaishnav, has selected efficient practicing lawyers of the High Court in commercial matters who are to be imparted training as mediators. Some of them, however, have been trained in the last month only. Training for another batch is scheduled in the month of June on reopening of the court after vacation. We are truly honored with the presence of Honorable Justice, Mr. Justice Vikram Nath on this momentous occasion to give a new shape to the arbitration center established by His Lordship. The commercial court in Gujarat are spread over the entire state. Even in talukas, the judges at the senior division and junior division levels are dealing with commercial matters. Section 12A, brought into force by Act 28 of 2018 with effect from 3/5/2018 provided for pre-litigation mediation and settlement in commercial suits and made it mandatory that in cases where no urgent interim relief is contemplated, the plaintiff has to exhaust the remedy of pre-institution mediation before bringing the suits to the commercial courts. Initially, subsection 5 of section 12A gave the settlement arrived in the pre-institution mediation proceedings to the status and effect of an arbitration award under subsection 5 of section 30 of the arbitration and 4 sorry subsection 4 of section 30 of the Arbitration and Conciliation Act 1996. However, section 12A has been substituted by Act number 32 of 2023, though date of notification is not known to me, to provide in subsection 5 that the mediated settlement agreement arrived at under section 12A shall be enacted in accordance with the provisions of section 27 and 28 of the Mediation Act 2023. Experience in the commercial court, however, has been that party approaching the court tries to avoid the pre-litigation proceedings by filing urgent interim applications casually at the time of institution of the suit. The role of the referral judges of the commercial court as such assumes significance. It has therefore become imperative to bring together legal professionals, mediators, judges, arbitrators, all stakeholders in the process to have a discussion before introducing the concept of mediation, conciliation in commercial arbitration, while giving a formal structure to the process by setting up a mediation center at the Gujarat High Court Arbitration Center. The first day of the conference is designed as a sensitization program for the stakeholders, and the second day is conceived as a capacity building program for the referral judges of the district judiciary. I heartily congratulate the executive chairperson of the Gujarat State Legal Services Authority, the president of the Board of Governors of the Gujarat High Court Arbitration Center in organizing 2 days conference with the aim to achieve the above objectives. The Board of Governors of the Gujarat State Judicial Academy needs special appreciation for providing all logistic support to make this conference successful. The collaborative efforts of these 3 institutions in conceptualizing and organizing the conference successfully will prove to be a milestone in the history of the Gujarat High Court. I must acknowledge at this moment that as a head of the institution, I feel blessed to have such a wonderful team of proactive colleagues and officers who extend unconditional support for any endeavor of mine. I am grateful to Justice Biren Vaishnav, the Executive Chairperson of the Gujarat State Legal Services Authority, and the President of the Board of Governors of the Gujarat High Court Arbitration Center, and Justice A. Y. Kokje, President of the Board of Governors of Gujarat State Judicial Academy, and their team for their persistent and positive support. I sincerely thank Mr. Tariq Khan, Registrar, International Arbitration and Mediation Center, Hyderabad, for giving concrete shape to my discrete ideas of organizing a sensitization program on mediation in arbitration and commercial disputes. I feel happy to have Mr. Tariq Khan and Mr. A.J. Jawar, 2 well-experienced arbitrators and mediators, as resource persons to conduct the program. I again welcome all the distinguished guests and participants for making this program successful by their presence. I am confident that under the able guidance of Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India, and well-experienced arbitrators and mediators as resource persons, this conference would be a grand success, and all stakeholders and judges of the district judiciary will be sensitized and enlightened on the subject mediation a tool for arbitration and commercial courts. I wish all the best to the organizers. Thank you. Jai Hind.
Thank you, Honorable Leadership. Atithi Devo Bhava. It's been once said that a multifaceted personality, when being honored, it's not the honor to a person, it's the honor the institution receives, that that person has actually chosen that I should go to the institution for being this. Our chief guest today falls in that category. And to honor the chief guest, Honorable Mr. Justice Vikram Nath, I'll request Honorable Mrs. Justice Sunita Agarwal ma'am, Chief Justice, High Court of Gujarat, first to offer bouquet and welcome Honorable Lordship with shawl and present the memento. We'll request Honorable Mrs. Justice Sunita Agarwal, Chief Justice, High Court of Gujarat, to present memento. It is a pachedi that is going to be presented to Honorable Mr. Justice Vikram Nath. Thank you, Honorable Lordship. May I now request Honorable Registrar General, Mr. Moolchand Tyagi, to felicitate Honorable Mrs. Justice Sunita Agarwal, the Chief Justice, High Court of Gujarat, by offering bouquet. May I invite Mr. Rohan Chudawala, Director, Gujarat State Judicial Academy, to offer bouquet to Honorable Mr. Justice Biren Vaishnav, Judge, High Court of Gujarat, and Executive Chairman, GSLSA. I request Ms. Neepa Rawal, Registrar Inspection, to felicitate Honorable Mr. Justice Kokche sir, Judge, High Court of Gujarat and President, Gujarat State Judicial Academy, by offering bouquet. Thank you, ma'am. With the permission of the chair, may I just recite a recital in a Gujarati that is just apt to the chief guest on account. I shall try, Lordship. It will be, Lordship. To my knowledge, it will definitely be guessed by Honorable the Chief Guest. He being there in Gujarat, and his Lordship always say that you can't keep Gujarat from Vikram. So it is just like this, that the multifaceted, illustrious personality, as Honorable the Chief Justice said, doesn't require any formal introduction to the House. It's the personality that has been aptly said in the contemporary digital era is vasaladi.com, Basuri that is, vasaladi.com, morepeach.com, vasaladi.com, morepeach.com, .com વૃંદાવન આખું કૃષ્ણાની ફેક્ટ ફાઇલ એટલી વિશાળ છે કે કયા કયા નામ એમાં રાખું. The amount of characteristics that have been narrated by Honorable the Chief Justice with respect to our chief guest, as would make out that there would be, definitely speaking, a long time that will be gone. But one thing that's for sure on account that probably the history will note on account and will positively remember Gujarat forever, that it's the most difficult time of COVID pandemic, that since inception, not for one day, functioning of either a district court or the High Court of Gujarat has been affected for the visionary leadership of Honorable Mr. Justice Vikram Nath, who made sure that through virtual mode, each court gets operated. Justice never sleeps. Without being much of a facade between the August House and Honorable Mr. Justice Vikram Nath, today is our chief guest. Now I'll invite our chief guest, Honorable Mr. Justice Vikram Nath, to have his presidential address.
इस हॉल में उपस्थित सभी लोगों को मेरा प्रणाम, नमस्कार। आप लोगों ने पहले से इतनी तालियां बजा दी है, मुझे लगता है मैं बोलूंगा तो बजेगी कि नहीं बजेगी। ऑनरेबल चीफ जस्टिस हाई कोर्ट ऑफ गुजरात मिस सुनीता अग्रवाल, एग्जीक्यूटिव चेयरमैन गुजरात स्टेट लीगल सर्विसेज अथॉरिटी मिस्टर जस्टिस बीरेन वैष्णव, प्रेसिडेंट गुजरात जुडिशियल अकेडमी Mr. Justice A.Y. Kogze, my dear brothers and sisters of judges of the Gujarat High Court, former Supreme Court judges, former Chief Justices, former High Court judges, I see them in a large number. I've worked with them. The most smiling face, the Gujarat High Court, Mr. Kamal Trivedi, Learned Advocate General. I see two very distinguished senior advocates who waited for 4 years for their, I won't say elevation, or their promotions. Former GP and Learned PP, presently Learned Additional Advocate General, Ms. Manisha Lav Kumar and Mr. Mitesh Amin. I also see former presidents of the Gujarat High Court Advocate Association, Mr. Pandya and Mr. Jadeja. Distinguished senior advocates of the Gujarat High Court Advocate Association, learned advocates, judicial officers, all other stakeholders for today's conference. And I'm told that there are two resource persons who have come all the way from Hyderabad to conduct the technical sessions. Ladies and gentlemen, the compere just mentioned about taking me out of Gujarat and Gujarat going out of me. So I remember in Kutch, when I was there for a function, I did say that you can take Vikram Nath out of Gujarat, but you cannot take Gujarat out of Vikram Nath. So that's a statement I had made then. Anyway, that still holds. Coming to Gujarat and Ahmedabad especially is homecoming to me. I really miss Gujarat all the time when I am there. And no day passes when I don't recall maybe any episode, discussion or a conversation or some mischief I was doing here throughout 2 years when I was teasing my brother and sister judges and lawyers at time. It's been really a great time which I spent in Gujarat. And now you have somebody again from Allahabad who is the Chief Justice here the last about 10 months now. I think in July and August 23. My former colleague and sister judge from Allahabad, we worked together. A very hardworking judge and can derive the maximum out of her team. And today also, like there's a saying, buy one, get one free. So she managed to get that out of me. I think that she learned here in Gujarat how to prosper and how to make money. So she invited me for this conference to be the chair, to be the chief guest. And in the meantime, in the evening yesterday, I was told that I have to flag off one children's bus also. So that's the 1+1 free. So that's the effect of Gujarat. How you can make maximum out of your investments. So you have a Chief Justice who's been a very long time trained mediator. He's very fond of arbitration and mediation. Very hard-working Chief Justice you have. And I think mediation and arbitration both will do well here. And Gujarat is now the first one to hold this kind of a conference to bring in mediation as a tool for arbitration before pre-arbitration proceedings. I will not go much into the subject because there are 2 sessions, 3 sessions today and tomorrow, which of course the stakeholders will be learning. I would not bore the guests here today for this function. But still a few lines on the topic. The topic goes like this: mediation, a tool for arbitration in commercial courts, an integrative approach to resolve commercial disputes. Now, basically, what I feel is, why is now arbitration being preceded by mediation? Earlier, regular court proceedings were being substituted by arbitration, alternate dispute resolutions, and all these things are coming up. Because what I personally feel is, there's a time when there's an old saying by Alfred Tennyson: old order changeth, yielding place to new, lest one good custom should corrupt the whole world. Now, regular litigation was failing. Delays, arrears, justice not being delivered in time, people losing faith in courts. Then this arbitration came up in a big way. Today you see arbitration everywhere, all over. So many conferences on arbitration being held. I don't know, but arbitration is also now, I believe, gradually losing, faith. People are trying to avoid arbitration for so many reasons. I'm not commenting upon any arbitrators or the lawyers who appear in the arbitration lawyers as they are called. They are making money, making their parties poorer. So instead of, and delays are also there, and then there's a 3-tier hierarchy in arbitration. So that is why now mediation is coming before arbitration, so that if things could be sorted out by mediation, maybe you don't have to go for arbitration. I don't know what is the reason, but then people are talking a lot about arbitration. There are petitions coming up where arbitrators are not deciding cases within time. There are petitions coming up where right from section 34, 37 is of course statutory remedies available, but intermediate stage also petitions are being filed challenging interim orders or decisions taken by the arbitrators. So a lot of delays in deciding arbitration matters. And then execution itself has a whole complete chain to go right up to the Supreme Court. So with so many tiers of litigation, both in domestic and international, I think that's why this mediation is now trying to curb or limit arbitration. If things go successful in mediation, then arbitration may not be required at all. And parties gradually may start thinking, that's right, mediation with no investment, nothing. You can sort out your problem by somebody trying to help you out. What are your weaknesses? What are your strengths? Sort it out instead of going in for litigation. Arbitration has become like a regular litigation. I'm not against it, but then that is the scenario. Nobody can deny this. This is a hard truth. So let's see how this conference goes, and I'm sure that all the stakeholders who will be attending the sessions today and tomorrow will go back with a lot of good understanding as to how to control and check litigation, arbitration, and sorting out issues by mediation. I appreciate and laud the effort of the 3 bodies which have organized this conference, namely the Gujarat High Court Arbitration Center, Domestic and International, Gujarat High Court Legal Services Authority, and Gujarat State Judicial Academy, under the aegis of which the present conference is being organized. I really appreciate that, and Gujarat is the first one to do it. Gujarat has many firsts, as earlier it has been said, and I always know that because I was here, and how many firsts we did, we cannot count. Uncountable. The time given is very limited. We don't keep you waiting and for the technical sessions to start. But before that, I have two Hindi couplets to read. As usual, not in Taranu, but straight. This is in Hindi. I hope all of you will understand. And if you don't, ask some of your friends who know Hindi, they'll tell you. It's very simple. पहले कोई विवाद न बेवजह कीजिए, पहले कोई विवाद न बेवजह कीजिए, बढ़ जाए तो रुक जाइए, न कलह कीजिए। कानून भी भारत का यही बोल रहा है, कानून भी भारत का यही बोल रहा है, असली है समझदारी, आप सुलह कीजिए। There's one more. पेशी मीन्स अटेंडिंग डेट्स इन कोर्ट। आप पेशी पे गए हुए हैं, हाई कोर्ट, डिस्ट्रिक्ट कोर्ट, कहीं भी। पेशी से भाग दौड़ से तन मन बचाइए, सेव योर सोल इन स्किन बोथ। पेशी से भाग दौड़ से तन मन बचाइए, जीवन बहुत है कीमती, जीवन बचाइए। तकनीक एडीआर की अपना के आप भी, तकनीक एडीआर की अपना के आप भी, ऊर्जा समय के संग ही धन को बचाइए, ऊर्जा समय के संग ही धन को बचाइए। Basically, this is the heart and soul of mediation. And pre-mediation, things can be sorted out, or pre-litigation, as everything is there now, it's all in the statutes. The CPC allows mediation, conciliation. There's a Mediation Act which has come up. The Commercial Courts Act statutorily requires, mandatorily requires a mediation exercise to be undertaken. So I am sure, let's see how well the mediation does in the next few years and maybe coming years. Maybe it will help reduce the litigation in this country and maybe internationally also. So with this, once again, I thank the organizers and especially the Chief Justice who gave me this opportunity to come to Ahmedabad and meet all of you and address. Thank you very much.
Thank you, Honorable Lordships, for inspiring note. I'll request Honorable Mr. Justice Viren Vaishnav to offer vote of thanks.
Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India. Chotu. Honorable the Chief Justice, Justice Sunita Agarwal, my brother Justice Kokje, judges, brother and sister judges of the Gujarat High Court, former judges of the Supreme Court, Mr. Justice C.K. Thakur sir, Justice Mohit Shah, former Chief Justice, former judges of the Gujarat High Court. Pardon me if I name a few because of my emotional attachment. Justice Javeri, with whom I shared the first bench, Justice Devani, with whom I also shared the bench, the captain of the team who, though retired, would never retire, Justice Shastri, Justice Brahmbhatt, Sir, with your permission, if I can try some Hindi. शुक्र है शुक्रिया बनाने वाले का कि उसने एहसान के बदले तहजीब दिखाया, और शुक्र है एहसान करने वाले का जिसकी वजह से किसी ने यह शब्द बनाया। We have a Chief Justice who, pardon me if I say, is a hard taskmaster, and it is very difficult to match up to her speed. It's a mere coincidence that we have Prayagraj, which is the king of among the 5 Prayags, 2 of whom are present on the dais today. It's a sangam of judicial officers, mediators, lawyers, arbitrators, and judges who will deliberate over the topic for over 2 days. And yes, for Justice Vikramnath, if I can be very personal, I am very fond of him. And it's a personal thank you, sir, for having made it today. That was possible only because of our Chief Justice. Thank you to the team of the Gujarat Judicial Academy, Justice Kokje, my brother judges, and the judicial officers of the Academy, Gujarat State Legal Services Authority, Rahul Trivedi especially, Member Secretary, the Board of Arbitration, Hital Pawar. Without this team and the members of the registry, the conference that is conceived wouldn't have been possible. A big thank you to all of you, and we look forward to an engaging session for over a period of 2 days. Thank you very much.
Thank you, Honorable Lordship. May I request all in the House to rise for national anthem? Thank you.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंग विंध्य हिमाचल यमुना गंगा उज्ज्वल जलधि तरंग तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
With this, we culminate the inaugural session. There is a health break of 20 minutes. I request all the participants to hurriedly come back. In 20 minutes, we'll be having best of sessions where Honorable Lordships are going to deliberate. Honorable Dignitaries, arrangement for the health break and tea has been made at 3rd floor at Banquet Hall.
Welcome back. A very good morning to one and all. Abraham Lincoln once urged lawyers, I quote, discourage litigation, persuade your neighbors to compromise whenever you can. As a peacemaker, the lawyer has superior opportunity of being a good man. I unquote. We are now proceeding with the first session of this conference. This session reflects the central theme of the conference. The subject is ADR to be made appropriate dispute resolution instead of alternative dispute resolution, and also exploring the concept of mediation in form of conciliation in commercial arbitral disputes. There can be no better panel to deliberate on the subject than the one we have. Honorable Mr. Justice Vikram Nath, Judge Supreme Court of India, and Honorable Mrs. Justice Sunita Agrawal, Chief Justice High Court of Gujarat. आवाज है ऐसी जिसे हर कोई सुनना चाहे, आवाजें ऐसी जिसे हर कोई सुनना चाहे, शख्सियतें ऐसी जिनसे हर कोई बातें करना चाहे, मिलना चाहे. Their voice and their personality rule over their audience. They work with strong determination and confidence. They embody the qualities of strength, empathy, wisdom, and compassion. Friends, they are none else than Honorable Mr. Justice Vikram Nath, Judge Supreme Court of India, and Honorable Mrs. Justice Sunita Agrawal, Chief Justice High Court of Gujarat. Once again, a big round of applause for them. When we talk of mediation, the pain of litigants, रफी साहब की कुछ दो लाइनें मुझे याद आ रही है. कौन रोता है किसी और के खातिर दोस्त, सबको अपनी ही किसी बात पे रोना आया. May I request first, my lord, Honorable Mr. Justice Vikram Nath, to enlighten the august audience.
मेरा प्रेजेंटेशन ऐसे है नहीं. हाँ मैडम का इस्तेमाल. Once again, I am back. So this is now going to be a prepared speech and address, not like I am used to talking, but I've been given a difficult task by the Chief Justice, but still I have to perform. So I'll deliver my best. Good morning, my fellow judges, esteemed guests, and everyone who has joined to here today for this session. As we commence the first day of conference with this session, I shall be addressing the theme of ADR to be made appropriate dispute resolution instead of alternative dispute resolution, with specific emphasis on mediation in the contemporary era of justice delivery system. I have broadly categorized my address into following subheadings. First, mediation, then desirability of mediation, mediation in other statutory frameworks, mediation in commercial disputes, statutory analysis of Mediation Act 2023, global trends in mediation, key takeaways, some suggestions, and then conclusion, link mediation with justice delivery system. Mediation, negotiation, and arbitration are considered to be three primary methods of alternate dispute settlement. In today's world, arbitration has become an expensive affair, resulting in restricted access to arbitration. The fee structure of the arbitrators has been a concern as it limits the utility of arbitration as a method for alternate dispute resolution. As we embark upon the mission of promoting mediation through institutionalization and statutory recognition, we must ensure that the mechanism remains cost-friendly and thus covering vast majority of disputes. In the last few years, mediation as a means of dispute resolution has a newfound popularity, and especially with the formalization of same in the form of Mediation Act 2023. There has certainly been a rise in discussions surrounding this mechanism, and justifiably so. However, it is a practice that has been traditionally used in our society to resolve conflicts and has stood the test of time and geographical boundaries. In Mahabharata, Lord Krishna also played the role of a mediator. In chapter 9, verse 29 of Sri Bhagavad Gita, he says, Samoham sarva bhuteshu name devesho stina priyah ye bhajanti tu mam bhaktya maite teshu chapayam. Means, I am equally disposed to all living beings. I am neither inimical nor partial to anyone. But the said devotees who worship me with love reside in me, and I reside in them. Or in short, I envy no one, nor am I partial to anyone. I am equal to all. That is the role of a mediator. He is an independent entity, not connected to the parties in any way. Taking the stance is the ideal approach for a mediator. Before the Battle of Mahabharata began, Lord Krishna tried to get the two warring sides to come to a settlement by discussion without shedding blood. He proposed various alternatives, such as land concessions and appeal to higher authorities. He served as messenger and personally took letters back and forth between the two camps. In some ways, mediation involves the awakening of a deeper understanding among disputants. Alas, the great battle of Kurukshetra still happened. That is because Lord Krishna was solely a mediator, and the ultimate fate resided in the hands of Pandavas and Kauravas themselves. This throws light on the fact that the mediator's job is to try and help the parties to come to a mutual understanding themselves and not impose on them what he believes to be right or just. All of us are also well aware how panchayats acted as the primary platform for dispute resolution at the community level in our society for ages. Of course, one can very well argue how panchayat resembled a setup which shares its likeliness more with an arbitration system with sarpanch as its head in the form of an arbitrator. But in actual practice, since the traditional communities were closely knit, such panchayats focused more on a collaborative approach from the parties, which resides at the heart of mediation. With regard to legislative adoption of mediation in statutes, 99 amendment in CPC paved the way for Section 89, whereby mediation was envisaged as one of the modes of settlement of disputes. The said amendment was made on recommendation of Law Commission of India and Justice Malimat's report. Even though Section 89 provides for mediation as an alternative method of dispute resolution, Justice Malipat Committee had earlier recommended making it obligatory for the court, after framing the issues, to refer the dispute for settlement either by way of arbitration, conciliation, or mediation, or judicial settlement through Lok Adalat. In case disputes fail to get resolved through any of the alternative dispute resolution methods, then the suit could proceed further. We have come a long way since then, and cut to present, we do have an elaborative mediation act in our hands. Before analyzing the outcome of the current statutory framework, it is important to highlight why we should encourage mediation, especially in commercial disputes. Mediation is a process through which a neutral and trained intermediary, known as mediator, assists the parties to reach a mutually beneficial settlement in a dispute. It is the least formal mechanism in ADR, as it allows the parties to play active role in settlement. The role of mediator is limited to facilitate the dialogue between parties rather than actively navigating through the process by proposing terms of settlement. Additionally, the benefits of confidentiality and voluntary nature of proceedings help the parties to speak their mind freely. It is also the most economic mode, as no exorbitant cost is to be paid to mediator, unlike costs of arbitrator or a counsel. Further, a successful mediation resulting in a settlement can be formalized before the court to sustain its binding effect. Commercial entities can thus maintain a healthy business relationship, look forward to continue the business together without suffering through financial costs. The potential of mediation to provide a win-win solution to a dispute can ensure greater degree of compliance as well. Similar reasoning applies in commercial disputes as well to an extent because the commercial relations are important for parties to preserve their legal battles. In commerce-oriented states such as Gujarat, the mediation gains more potential because the family and business go together due to inherent trust among one's kin. For example, a company is established by a joint family, including a brother and a sister, along with their spouses using ancestral property of their parents. The close relationship would help them for establishing a business. A subsidiary company was also founded by the brother and sister in name of their cousin, with internal understanding and trust on each other. Later, a misunderstanding had arisen between the brother and his cousin, due to which a petition was filed under the allegation of oppression and mismanagement against the brother. However, as the real conflict lied in family dispute and internal misunderstanding, mediation would be more appropriate and desirable mechanism. Mediator can help the parties to think calmly, sit together and communicate freely to go to root cause of the dispute, rather than engaging in time-consuming, rigorous legal proceedings before company tribunal and later before the court. The statutory and judicial framework in India has always supported and encouraged outside court settlement through ADR. Indian courts have been actively and routinely referring the matters to mediation. Mediation centers have established throughout the country. As per the Survey of Dispute Resolution in India 2023, conducted collaboratively by the Federation of Indian Corporate Lawyers and the Center for Trade and Investment Law, mediation conciliation has been rated as the second most preferred way to resolve disputes in India. Apart from CPC, there are other legislations as well, which empower the reference to mediation. For example, Section 442 of the Companies Act 2013 provides that the mediation and conciliation panel be maintained by the central government for the mediation of cases before the central government or the NCLT or NCLAT. Further, the Consumer Protection Act 2019 also has multiple provisions enabling mediation of consumer disputes. Additionally, Chapter 5 of CPA contains provisions concerning the establishment of consumer mediation cells attached to the district commissions and the state commissions, and the procedure for mediation in consumer disputes, among others. These provisions in special enactments also indicate utility of mediation in varied types of disputes. Mediation has been institutionally attached to courts, providing the legitimacy and compatibility with court-related procedures. While alternative dispute resolution methods are useful tools in settling vast majority of disputes, including contractual disputes, family law-related disputes, their desirability for commercial disputes must be specifically highlighted. The legislative efforts to encompass these methods in settling commercial disputes was evident from Commercial Courts Act 2015, making it mandatory for parties in commercial disputes to first attempt mediation before filing a case. This pre-institution mediation was intended to cover vast majority of commercial disputes, as the minimum monetary threshold to be covered in this provision was brought down from 1 crore to 3 lakhs by the same amendment. Now we can look at the outcome of legislative efforts to promote mediation in commercial disputes. In 2015, the Commercial Courts Act furthered the tool of mediation by incorporating it as mandatory pre-litigation provision. Along with the provision for pre-litigation mediation, the Commercial Courts Pre-Institution Mediation and Settlement Rules 2018, or the PIMS rules, have also been framed by the government under the Act to further provide guidelines on the process. However, a challenge was posed to Section 12A of the Commercial Courts Act before the Supreme Court. On 17th August 22, the Supreme Court in Patil Automation Private Limited versus Raheja Engineers Private Limited, reported in 2022 SCC Online, Supreme Court, page 1028, held that Section 12A of Commercial Courts Act makes the pre-litigation mediation mandatory. Thus, a suit cannot be filed before commercial court before exhausting the option of settling the dispute through mediation. The court refused to consider Section 12A as a mere procedural provision. Rather, it held that since a settlement under Section 12A of the Act is accorded the status of an award under the Arbitration and Conciliation Act, it unerringly points to the object of the legislature to make pre-litigation mediation compulsory. Also, any suit instituted in violation of the mandate under Section 12A must be visited with suo motu rejection order under Order 7 Rule 11 of CPC by courts. The ruling is based on textual interpretation of the provision. The court also noted the objective of Commercial Courts Act is a unique experience to push the pace of disposal of commercial disputes. Further, it particularly noted the benefits of mediation as a tool to lessen the burden on court in the era of docket explosion. It is in this background that court interpreted Section 12A. Although the ruling of Supreme Court could be supported by both the textual and purposive methods of interpretation, we can utilize today's occasion to test the practical impact of decision. Effectively, in case of non-compliance with pre-litigation mediation, the court can exercise powers under Order 7 Rule 11 of the CPC to suo motu reject the plaint after hearing the plaintiff and recording its reasons. We can see the reflection of this ruling in some recent decisions of Delhi High Court, whereby plaint was rejected for being not maintainable and plaintiff was directed to file fresh suit after complying mandatory provisions of law under Section 12A of Commercial Courts Act. The pre-institution mediation and settlement rules 2018 have also been framed by the government under Section 12A of Commercial Court Act. As per the rules, the plaintiff must file an application for mediation before the authorities instituted under the Legal Services Authorities Act. The authorities subsequently issue a notice to the other party for appearance within 10 days. In case the other party fails to appear, the mediation process is treated as a non-starter and a report is prepared accordingly. On the other hand, if the opposing party agrees to participate and arrives at a settlement, it is recorded in a settlement agreement. Furthermore, the parties have the freedom to engage a counsel during mediation, and as far as expenses are concerned, they are limited to a one-time fee, which is quite economical, also having regard to the fact that it is to be shared equally. An illustration. A commercial example would be that of a trader engaged in import-export of Italian marbles. Trade and supply agreement between the trader and supplier was disrupted due to external circumstances in another country. However, the supplier in India had to suffer immense financial and reputational loss due to the disruptions. The trader had also suffered losses and thus was unwilling to pay the damages as contemplated in the agreement. He also took the plea of force majeure. If the parties directly approach the court and start the wheel of legal machinery, they would not only lose the time and money, but also they would lose goodwill with each other, thereby losing the future business and perhaps the current clientele. Thus, perhaps it would be better for them to approach mediation and try to settle the dispute sooner, ensuring that interests of both parties are protected. Here, I would also like to speak a little about the Mediation Act. I believe that the Act is a major step forward in recognizing, facilitating, and promoting mediation as a means of dispute resolution. Only some of the sections of this Mediation Act 2023 have been notified to be enforced. Some part of the Act is yet to be notified. The framework of the Act is a wide encompassing one and ranges from provisions of a body of registered mediators to even encouraging community mediation. However, I firmly believe that the statute has appreciable ingredients to it, which will enable mediation to become a go-to tool for resolving commercial disputes in the near future. The application clause extends to the parties which have their place of business in India and does not limit itself only to parties residing in India. This can be nothing but a welcome change in an atmosphere that increasingly demands ease of business. It is equally vital that the government agencies, public bodies, corporations, and local bodies are also included within the confines of the Act, where the matter pertains to a commercial dispute. Unquestionably, it broadens the horizons of scope of mediation in disputes surrounding commercial matters. Further, the definition of mediation itself within the statute seems to be a comprehensive one, where it includes mediation, pre-litigation mediation, online mediation, community mediation, as well as conciliation, and goes beyond it to include any other expression of similar import, provided the process resolves around the parties attempting to reach an amicable settlement of the dispute with the assistance of a mediator. This also brings me to another facet of this process of mediation, which is the role of a mediator. I am of the opinion that one of the major factors due to which mediation deserves to be adopted as a premier choice as often as it can be is because of the alluring role that the mediator partakes in this conflict resolution. Section 15 and 16 of the Act are primarily the provisions that deal with the role of a mediator in the conduct of mediation. Mediator is an individual who assists the parties in an independent, neutral, and impartial manner. The key word here is assist, as opposed to any manner of imposition, and that is what lends to mediation a flavor that is entirely based on parties centric approach. In the process of mediation, a mediator is guided by the principles of objectivity and fairness in order to uphold the basic tenets of voluntariness and self-determination. As per section 16(1) of the Act, a mediator is supposed to emphasize that it is the responsibility of the parties themselves to take decision regarding their claims. This places the parties in an active seat to curate their own path of conflict resolution instead of the traditional approach of being led by counsels and judges in the courtrooms. The legal sanction accorded to mediation by this Act also attains another progression in light of Section 27, which seeks to enforce a mediated settlement agreement in accordance with the provisions of CPC in the same manner as if it were a judgment or decree passed by a court. It is undeniably supposed to bring a sense of finality to these mediation proceedings, which can be challenged only on limited grounds expounded in Section 28. Another affirmative aspect of the statute is the inclusion of international mediation, which specifically relates to commercial dispute arising out of a legal or contractual relationship where the party resides or has its place of business in any country other than India. In a country like ours, where we aim to become an international hub of commerce, which inevitably implies increase in conflicts, herein mediation can certainly act as a breakthrough mechanism. I must also highlight how the statute also provides for online mediation. Legal acceptance of online mediation certainly turns it into a cost-effective process which can transgress distant boundaries effortlessly. May I add that in an era where Supreme Court is live streaming its proceedings and virtual appearances are a norm, it is the only natural step to adopt online medium in processes like mediation as well. Another pivotal feature of the Mediation Act, and of course one of the most important ones, especially in matters pertaining to commercial disputes, is the ideal time structure that it provides for completion of mediation, that is 120 days, which may be extended for not more than 60 days. I cannot emphasize it enough, and each one of you, in a way, know it all too well how time effectiveness plays at the core of commercial disputes. The codification of a practice which was led loosely for a large part shall make a paradigm shift in level of faith that has been reposed by parties, practitioners, as well as the institution itself in the approach to mediation. Just to provide a little perspective, I would also like to add about the growing global trends in mediation and the key takeaways from it, which can help us as a nation. For instance, there has been an apparent willingness in France to make mediation as a more appealing alternative, where the average success rate of commercial mediation is above 70%. Similarly, in New Zealand, mediation remains a preferred forum of choice for parties to litigation, with the courts increasingly urging parties to explore ADR options, including use of judicial settlement conferences. While the practices vary from country to country, mainly due to difference in cultural and legal systems, there has been a general upsurge in adoption of mediation to usher in a genuine mechanism for delivering justice. Even though mediation as a system is supposed to be flexible and feed itself as per the needs of the parties, but there are certain practices which can be incorporated to make it smoother. Like in UK, there is a trend surrounding the use of two or more mediators in cases involving multiple parties with different interests to be reconciled, wherein the mediators can conduct individual breakout sessions and sessions with subgroups of parties separately or jointly. This has a chance to lower the overall friction between the conflicting parties. Likewise, in the Italian model, once the applicant has filed a mediation request before instituting a suit, the parties are required to mandatorily attend an initial mediation session with the mediator, where the process is explained to the parties and lawyers. Subsequently, if the parties, after understanding the process and weighing its pros and cons, choose to mediate, such mediation is concluded within 90 days from initiation. Since this model provides an opportunity to the parties to voluntarily choose mediation after clearly understanding its process and effects, it can infuse further trust in the minds of parties. There was a very famous movie made on Mark Zuckerberg, the man known for Facebook. I suppose most of you must have heard about the 2010 movie called Social Network, which is based on famed Mark Zuckerberg and origin of what we now know as Facebook. This is an important lesson on mediation that the movie can teach all of us. A lawsuit was initiated by the twin brothers, Winklevoss, who claimed that Zuckerberg stole the idea for Facebook from them. Zuckerberg countersued, and the district court in California ordered the parties to mediate. Facebook, the competing website, ConnectU, and the Winklevoss twins were all party to the mediation. Before the mediation began, the participants were made to enter into a confidentiality agreement since the stakes in the matter were so high, be it the financial amount or cost in terms of intellectual property rights. Finally, a full day of negotiations resulted in a signed term sheet and settlement agreement. Yes, of course, there was a further dispute between the parties regarding the settlement term sheet, but that's a story for another day. The point that I seek to highlight today is that if a commercial dispute of such magnanimity, which included all manners of plot and twists and hidden truths, can be resolved using mediation as a tool, then why can't we not embrace mediation with open arms in our dispute resolution mechanism? For enforcing mandatory mediation at pre-litigation stage, it is vital to have organized and well-maintained machinery for mediation. In absence of institutionalized system, the mediation cannot present itself as first option to parties, especially considering the expected role of mediation at large scale. We must aim at creating a robust cadre of professional mediators who can actively encourage the parties to participate in mediation with free mind. The primary doubts in minds of parties about the cost, time, confidentiality, enforceability of settlement, role of arbitrator can be clarified through sensitization and training for lawyers as well as judicial officers. The high courts and district courts in various states can take the initiative of establishing institutions dedicated toward mediation in commercial disputes. Considering the statutory recognition and ease of procedure, mediation has potential to reduce the burden of commercial disputes on judiciary. However, we must also focus on sensitization about mediation and training of mediators. As I mentioned, the Italian model, where parties are made aware of all the contours of process. Similarly, in India as well, parties must be made aware of financial and mental benefits of mediation over adversarial court proceedings. The mediators must exhibit empathy through active communication with parties so that parties feel comfortable to raise their real interests in settlement. Assisting the parties to reach to the root of the dispute must be one of the most important tasks of a mediator. Further use of regional languages in mediation could help immensely for parties to arrive at settlement, especially at district courts. Parties would feel familiar and reliable with the mediator, leading to better outcomes. We must also focus on efficient infrastructure to create sustainable structures to ensure that mediation does not remain a mere provision in law, rather it becomes a common practice in commercial world. As the law has already made it mandatory, it's necessary to create the facilities to support the legal mechanisms. Thus, a combined impact of effective statutory framework with infrastructural facilities can help to utilize mediation to its highest potential. On a concluding note, I would like to stress upon the fact that the ultimate objective of a traditional justice delivery system, of which every day we are a part of in courtrooms, and a setup such as mediation is identical, at least when it comes to civil and commercial disputes. One of the primary focus of courts in recent times has been to clear areas of cases because unfortunately the legal system is infamous for never-ending battles in courtrooms. In this concern, I perceive mediation can do wonders by resolving disputes which have the potential of being mutually resolved by the parties instead of knocking the doors of court. Thereby can help ease the backlog of cases in an already overburdened system. This reminds me of the impactful lines said by late Sandra Day O'Connor, former Associate Justice of the Supreme Court of the United States, in fact, the first female judge of the US Supreme Court. The courts of this country should not be the places where resolution of disputes begin. They should be the places where the disputes end after alternative methods of resolving disputes have been considered and tried. Moreover, I ask each of one of you, doesn't mediation increase the chances of both the parties to reach a mutually satisfactory result to the maximum extent possible? I firmly believe it does, and in the process, it maximizes the parties' perception of substantive justice they have gained out of the entire exercise. The solution is not simply black and white, and no party emerges as a clear, legally right or wrong. But at the end of a successful mediation, what party takes away home is not only a sense of contentment, but also a continued relationship in future. I would like to end my note on the remark that if we give mediation a fair opportunity, the judicial efforts combined with robust institutionalization could potentially reduce the burden on both the courts and litigants to settle the commercial disputes in cost-effective manner. Thus, the very topic that ADR should be made an appropriate dispute resolution instead of alternate dispute resolution is the slogan for today and the conference today and tomorrow. Thank you very much.
The August gathering, which also includes the presence of the law college students, is highly enlightened, my lord. We are highly obliged. May I now request Honorable Mrs. Justice Sunita Agarwal to address this August gathering.
ये आ जाएगा, इस पे आएगा, ये भी वो नहीं है ना। Good afternoon to all of you. Before deliberating on mediation, let us have a look on the root cause of the dispute. In every society, conflicts naturally arise from a multitude of factors spanning political ideologies, economic disparities, social and cultural differences, language and religious beliefs, scarce resources, etc. In a relationship, conflict is a state of opposition and disagreement of the people. Conflict is usually based upon a difference over goals, objectives, or expectations between the individuals or groups. Simply put, no two persons in the world are absolutely the same. No two persons can feel or think alike. The difference between thinking of different people causes conflict. There is a positive side of the conflict too. Conflict is the root of personal and social change. Conflict prevents stagnation. It stimulates interest and curiosity. Given their inevitability, it becomes imperative for societies to establish effective mechanism for conflict resolution. From the ancient times, India, as well as other Asian countries, have cultivated a rich tradition of addressing disputes through collaborative and amicable means. This tradition emphasized on negotiation, mediation, and consensus building by prioritizing dialogue and understanding over confrontation and aggression. By embracing this approach, the nations have fostered environments conducive to peaceful coexistence and sustainable development, thereby serving as exemplars of harmonious conflict resolution for societies worldwide. In this regard, the provisions of alternative dispute resolution methods emerged as a pivotal strategy. Section 89 of the Civil Procedure Code, amended in 2002, emphasizes utilization of ADR mechanisms such as arbitration, conciliation, mediation, and judicial settlement, including settlement through Lok Adalat. When it appears to the court that there exists element of a settlement which may be acceptable to the parties by embracing alternative dispute resolution methods. Parties involved in the dispute can engage in constructive dialogue, negotiations, and consensus building, thereby bypassing prolonged legal battles and advancing mutual understanding. The adoption of alternative dispute resolution methods underscores a commitment to resolving conflicts in a timely and efficient manner, ultimately promoting harmony and stability within societies. The Arbitration and Conciliation Act 1996 governs the procedures and legal framework for arbitration and conciliation in India. It provides a comprehensive set of rules and regulations for the conduct of arbitrations and conciliation proceedings, including the appointment of arbitrator, enforcement of arbitration awards, and the settlement of disputes through conciliation. Additionally, the Legal Services Authorities Act of 1987 establishes Lok Adalats as an alternative dispute resolution mechanism in India. These adalats aim to provide speedy and cost-effective resolution of disputes, particularly focusing on settlement through conciliation and mediation. Both the process of arbitration and Lok Adalats have statutory backing for the enforcement of their final decisions or awards. Addressing the complexities in arbitration, I may focus on three aspects. First is appointment of arbitral tribunal. Though the parties' autonomy has been given supremacy to appoint arbitrators of their choice, but failure to arrive at any agreement results in the intervention of the courts and hence delays. One of the key objectives of the Arbitration and Conciliation Act is minimization of the supervisory role of the courts, but in practicality, the parties having not reached at any consensus as they do not have support of a neutral intervener keep on approaching the court for the lack of trust in each other. Such repeated acts serve as deterrent for people opting arbitrations and actually backfire, thus frustrates the purpose of Arbitration Act, providing speedy disposal of disputes by an amicable, swift, and cost-efficient settlement process. The second aspect is of enforceability of arbitral awards. Contrary to the belief that an arbitral proceedings would come to an end when the award is pronounced, the real litigation starts when the award is to be enforced post-pronouncement. For reasons best known to the legislatures, it has chosen to make the arbitral awards subject to challenges before the trial court, though on limited grounds. Concurrent jurisdiction of appeal is with the high courts. Many old appeals under Section 37 of the Arbitration Act, about 5 to 10 years old, are pending in the High Court, and one or the other party suffers because of litigation. The arbitration experience, particularly for the successful claimant, can rather prove to be painful, prolonged, and lopsided, conveniently negating the idea of quick and effective resolution. One can only imagine the plight of a successful claimant who cannot enjoy the fruits of the arbitral award until such procedural challenges come to an end. The third aspect is cost and time. In the past few years, the scope of arbitration costs have become wider. Arbitration costs now involve the fee payable to the arbitrator towards reading charges, sitting fees, award writing fee, and other expenses, coupled with the cost involved in arranging sittings, sometimes travel charges for the parties, witnesses, counsel, and arbitrator. It must be noted that the process of arbitration will prove to be cost efficient only when the number of arbitration proceedings are limited. However, the delays caused by the judicial intervention drains the parties financially as the arbitration becomes litigation in disguise. Ironically, the speed and cost efficiency are the hallmark of the procedure and the reason why arbitration is preferred over litigation as a viable option for dispute resolution, especially in commercial disputes. Adopting integrating method under Section 30 of the Arbitration and Conciliation Act 1996, the use of mediation, conciliation, and other procedures has been incorporated to encourage settlement of the disputes with the agreement of the parties at any time during the arbitral proceedings to encourage settlement. Hence, if during the arbitral proceedings the parties settle the dispute through mediation or conciliation, the arbitral tribunal shall terminate the proceedings. Conciliation in commercial arbitration disputes involves a process where parties seek to resolve their differences with the assistance of a neutral third party known as a conciliator. Unlike arbitration, where a decision is imposed upon the parties, conciliation aims to facilitate a mutually acceptable agreement through dialogue and negotiation. The process of conciliation is delineated in detail from Section 62 to 76 of the Arbitration and Conciliation Act 1996. It stipulates the manner in which notice is sent, appointment of conciliators, submissions of the statements, role of the conciliation, confidentiality, and the settlement agreement. A new concept of mediation and settlement is introduced by the parties in arbitration clause itself, which is named as multi-tier dispute resolution clauses. Although it is not a part of convention's requirement, parties sometimes provide that a certain action or event must occur before arbitration. For example, mediation, negotiations, or the lack of jurisdiction of a special court could be conditions precedent to the filing of an arbitration application. These preliminary procedures are designed to help both parties to resolve any dispute before taking the subject to court or arbitration. Such articles often begin with an obligation to negotiate, including bringing in top management, being involved in conciliation and or mediation process. The adjudicatory process, which is arbitration, is the final tier of these clauses to speed up the resolution of disputes, and it is employed only if the initial stages have failed. Multi-tier provisions are found in almost all types of construction contracts, service contracts that need specialized know-how, and turnkey contracts. A common problem with these conditions is when it is unclear whether the provision is merely preferable before the arbitration or it is required necessarily to initiate a proceeding. Thus, it raised a lot of debate regarding the mandatory nature of pre-arbitral processes and steps provided under a clause, dispute resolution clause. The courts have picked their brains on this issue at multiple occasions and reached differing conclusions. If we compare between arbitration, mediation, and conciliation, arbitration and mediation serve as alternative dispute resolution methods, each with its distinct features and benefits. Mediation, being a voluntary process, allows parties to engage in discussions facilitated by a neutral mediator and is characterized by its flexibility and informality. In mediation, emphasis is on communication, understanding, and preserving relationship. During mediation, the neutral mediator, though controls the process, but parties keep their autonomy throughout. The mediator acts as a facilitator and by bringing the parties to the negotiation table, helps them to resolve their differences, which is the most natural and cost-effective method of dispute resolution. In contrast, arbitration renders a binding decision akin to a court judgment arrived at by undertaking a formal procedure involving hearings and evidence presentations. The party's autonomy is restricted to the stage of appointment of arbitrator and extension of the mandate of the arbitrator. The procedural laws control the whole process. Mediation stands out as a superior tool for dispute resolution due to its emphasis on parties' autonomy and control over the process. Unlike arbitration, where a third party renders a binding decision, mediation empowers parties to actively participate in bringing their own solutions. This autonomy encompasses a sense of ownership and investment in the outcome, increasing the likelihood of a mutually satisfactory resolution. Additionally, mediation offers a non-adversarial environment conducive to open communication, enabling mediator to address the parties' underlying interests and concerns without even letting them know that he is in the control of the process, which will never surface in a formal arbitration settings. The Mediation Act 2023 has been enacted to promote and facilitate mediation, especially institutional mediation for resolution of commercial disputes under the aegis of a mediation service provider. It provides a robust legal framework for mediation in India, encompassing provisions for appointment of mediators on an application made by a party to a mediation service provider, where the parties do not reach at any agreement upon the name of the mediator and the procedure for their appointment. While making appointment, the mediation service provider has to consider the preference of the parties, apart from the suitability of the mediators. A mediation service provider is empowered to terminate the mandate of a mediator in certain eventualities and appoint another mediator from the panel maintained by it. The process of commencement and conduct of mediation is regulated by Section 14 and 15 of the Mediation Act 2023. The Act provides for the enforceability of mediated settlement agreement and the grounds of challenge to a mediator settlement agreement. The Act conceptualizes an establishment of the Mediation Council of India by the notification of the central government as a body corporate to perform the duties and discharge the functions under the Act. Considering mediation a tool for conciliation in commercial disputes, it may be noted that the mediation serves as a valuable tool for conciliation in commercial arbitration disputes, offering parties an alternative avenue for resolving conflicts outside the formal arbitration process. In commercial arbitration, disputes often arise from complex business relationship and contractual disagreements, which can impede the process of arbitration proceedings. By incorporating mediation into the arbitration process under Section 30 of the Arbitration and Conciliation Act 1996, parties can explore creative solutions and reach at mutually beneficial agreements without the need of a binding arbitration award. This can be particularly advantageous in commercial disputes where preserving ongoing business relationship is paramount. Mediation encourages open communication and empowers parties to customize solutions that address their specific needs and interests. Furthermore, mediation in commercial arbitration disputes can help to streamline the arbitration process by resolving preliminary issues or narrowing down the scope of the dispute, thereby saving time and resources. Additionally, mediated agreements can serve as a foundation for future collaboration and mitigate the risk of future disputes. While expanding the scope of while expanding mediation horizon, embracing conciliation and commercial arbitration disputes, the Section 12A of the Commercial Courts Act 2015 deals with pre-institution mediation and settlement, which is commonly called as PRIMS. It was introduced by Commercial Courts, Commercial Division and Commercial Appellate Division of the High Courts Amendment Act 2018 to encourage the settlement of commercial disputes through mediation before initiation of litigation. The legislative intent behind this amendment is to reduce the burden on courts and to promote the resolution of disputes through alternative dispute resolution mechanisms. The history of insertion of Section 12A reflects a broader global trend towards embracing consensual and collaborative approaches to conflict resolution instead of traditional litigation because of adversarial nature. The provision mandates pre-institution mediation for all commercial disputes of a specified value unless the plaintiff seeks urgent interim relief. This approach aligns with the global practices and is aimed at ensuring that only genuine cases that require judicial intervention are brought before the courts. The introduction of PRIMS under the Commercial Courts Act is also a step towards improving India's ranking in the annual Ease of Doing Business Index formulated by the World Bank, as it aims to provide speedier adjudication of commercial disputes. So, what is the way forward? In the modern days, due to rapid increase in commercial disputes, the interest in mediation has increased immensely. The increased interest towards mediation is directly attributable to dissatisfaction with the cost, time consumed, and lengthy and complicated procedures adopted in the traditional dispute resolution systems. This has made people and business entities to focus and consider the advantage of mediation, particularly its simple and easy procedure that offers parties full control over both the process of resolution and the outcome of the process. Since mediation is an amicable settlement of dispute, using mediation to settle the dispute has been proved very satisfactory because of high rate of success. Parties themselves deciding the outcome of the dispute is a notable feature of the mediation. An achieved result acceptable to both the parties to the dispute gives no scope for further litigation on the concluded subject unless there is a serious violation in the procedure adopted for the mediation. Considering its time and cost advantage and the balance of being, though structured but flexible procedure, mediation has been recently introduced for resolving the consumer disputes. Resolving the commercial disputes to provide win-win situation to the consumer and business entities. With fair degree of command, I can say that the Gujarat State Legal Services Authority in this direction has taken some important steps. Presently, in all 32 judicial districts, headquarters mediation centers have been established. Besides, in 45 talukas of 19 districts where institution of commercial cases are high in number, mediation centers have been established. Recently, 52 advocates of 45 talukas have been imparted 40 hours of mediation training. There are nearly 700 trained mediators in the state of Gujarat. In the last 3 years, nearly 9 capacity training programs have been organized, whereby more than 350 advocates have been imparted 40 hours mediation training. Thus, attempts have been made to remove infrastructural bottlenecks by the High Court, but approach to the provision by the stakeholders still appears to be mechanical or casual. To achieve the objectives of the legislative scheme, the institutionalization of mediation is much needed. A full-fledged mediation center equipped with trained mediators from amongst experienced practicing lawyers in the High Court is the need of the hour. Thus, it was apt to have a sensitization program for inculcating the acceptance of the concept of mediation and conciliation in commercial arbitration. Before setting up a mediation center for commercial disputes in the Gujarat High Court Arbitration Center, domestic and international. Having roster of Section 11 petitions, I have come across many arbitral referrals involving small amount of claims. Arbitration in such cases may prove to be a costly affair. So would be a situation in MSME arbitrations. ADR intends to provide cost-effective dispute resolution and hence an honest effort to redress the dispute between the parties before the arbitral proceedings by a trained mediator could be a game changer. There are many partnership disputes refer to arbitration. Many such cases involve brothers or family members as partners. Mediation could be a good tool for dispute resolution in such cases in a state like Gujarat, where family bonding and family values are kept above the individual interest in the society, as relationship between the parties can also be preserved. We have amongst us some of the finest arbitrators. Their tenacious and dedicated efforts are alien to none. My humble appeal is to all the distinguished arbitrators to sensitize the parties in apt cases to explore the avenue of mediation, as the same would definitely establish their credibility and respect in the institution. Thank you all for joining us in this effort. Jai Hind.
Deeply grateful, Honorable Ladyship. Honorable Madam, we are deeply honored and grateful for receiving such a knowledgeable address on the concept of appropriate dispute resolution, particularly emphasizing on institutional mediation in a commercial dispute, which holds profound significance in a state of Gujarat, which is a commercial hub. So on this note, let us remain steadfast in our commitment to mediation, appropriate dispute resolution, knowing that our efforts today will shape a more just and equitable tomorrow. With this, we are ending up this session, and I'm requesting dignitaries to kindly proceed for a lunch. Thank you, Lordship. Thank you, my Lord.
From Honorable Mr. Justice Vaishnav, sir, that won't look good to of our profound knowledge having resource person when we'll be deliberating with you and front rows remaining vacant. Please come forward. Thank you. Thank you. Thank you. The third technical session that we are going to deliberate is harmonizing the arbitration and mediation practices, exploring synergies and challenges. The beauty of the session is that these concepts are going to be deliberated by two of the finest resource persons who actually have got, I would be saying, who are not less than an encyclopedia as regards these two pivotal ADR modes, arbitration and mediation. We are having Mr. Tariq Khan, who is a registrar, International Arbitration and Mediation Center, Hyderabad. It will be a too prolix on my part to give a detailed introduction of his sir, but his greatness comes from the fact that he has taken down sessions with the Supreme Court judges of Maldives, Bangladesh, and Sri Lanka. He has occasion to visit National Judicial Academy as well. He has been appointed as a counselor mediator by NCLT, RERA, MSFEPC, and independent parties. He is a specialist mediator at Singapore International Mediation Center, ADR ODR International Accelerated Commercial Mediator. He's also trained the mediation from Madhyam International Council for Conflict Resolution. He has also carried out international arbitrations, and House is indeed privileged to have the presence of such a great resource person. In order to carry out our legacy and the rich tradition, may I request Registrar Judicial Mr. S.D. Suthar to escort Mr. Tariq Khan, Justice Biren Vaishnav, for felicitating our renowned resource person by offering bouquet and memento. Our another resource person for The session is Mr. A.J. Jawad, Senior Mediator Trainer. He's an advocate and arbitrator. Yesterday, when I had a discussion with Mr. Jawad on account, જો ગુજરાતીમાં કહું ચુડાવાલા સાહેબે કહું એમ પેપર ફોડું તો સેશન સ્ટાર્ટ કરવા માટે જ એમણે જે તમારા માટે એક મિસ્ટ્રી રાખી છે બહુ મજા આવે એવું છે સો a senior mediator from MCPC is a highly ranked by all the institutions. He is going for training all across the India. Talking about his professional summary, he has been attorney at law for 35 years. He's been practicing at Madras High Court and he's having a diversified field of practice. He's a senior mediator and he's been training since last 15 years. And he has proved his track record by conducting mediation training programs nationally and internationally. It's indeed a great matter of honor that Mr. Jawad is with us. May I request Honorable Ms. Pawar ma'am to escort Mr. Jawad to Mr. Justice, Honorable Mr. Justice A.Y. Kokje sir for felicitating by offering bouquet and memento. May I now request Director Gujarat State Judicial Academy to escort two of our resource person to dais. They're all yours. And it can be started. You can use podium or thank you.
Very good afternoon to all the participants, honorable judges, dignitaries on the dais, off the dais. Firstly, I'd like to congratulate Gujarat High Court and all the organizations that are involved and that have taken this initiative. And I must say that this is first of its kind. And I'm really glad that so many of you have participated. But before I begin, there are a couple of things that I'd like to highlight. Somewhere in 2018, I was attending a conference in Delhi High Court, where late Shri Falias Nariman was delivering his concluding remarks. And I remember what he said, that the future of arbitration is bright, but only because future of litigation is not. When I heard it, I was happy because I was doing some arbitrations and I thought maybe the field that I've chosen for myself, I'm pretty safe and arbitration is going to grow. But in the morning session, Lordship was mentioning how arbitration has become a mirror image of litigation. And I was reminded of Honorable Justice D.A. Desai, who on 29 September 1981 was dealing with a matter pertaining to the 1940 Act, the erstwhile Act of Arbitration and Conciliation. He commented on the functioning of the Act and said, interminable, time-consuming, expensive court procedures impelled jurists to explore alternative to the court system, and that led them to the Arbitration and Conciliation Act of 1940. However, the way in which the scheme of the Act has been implemented, and every award without challenge, without any exception, challenged before the court of law, has made lawyers laugh and legal philosophers weep. Pretty much by 1981, this was the situation of Arbitration Act. And thereafter, on 23rd October, finally, after the 96 Act came into the picture, we saw some amendments in 2015, and things changed from there. In 2021, I happened to, after listening to late Shri Falias Nariman, I authored a book called Everything You Need to Know About Arbitration. And I was very excited to have a foreword from Shri Falias Nariman because I've been looking at him as my mentor. And he wrote a 16-page foreword. I'll just tell you one paragraph from that foreword, which may be relevant today. He said, I support mediation, not because I'm skilled in it, but it is because my experience of 6-7 decades as a lawyer and few decades as an arbitrator has convinced me that mediation shall be preferred, not only over adversarial arbitration, but also over adversarial litigation. The question now therefore comes as to why this sensitization program is required today. Until the society attains the maturity which is required to adopt mediation as a dispute resolution mechanism, it is only for the courts to explain to the parties, to make them understand how this is a viable option. Because I was reading the Niti Aayog report. I don't know how accurate it is, but the assessment is, I think in 2018, that if no new case is filed in a court, it will take us 324 years to finish the pendency. Is it humanly impossible? I think it would be unfair to expect that this pendency can get over on its own, or it would be possible that without using these tools that are given under Section 89, because that is something we have to use, and we have to use it as a resource to complement the existing court system. Because the more number of referrals, the more will be the success rate of arbitration and mediation. So far as arbitration is concerned, I don't think there is a need to push arbitration at the moment because A, it has become a mirror image of litigation, and B, it's already the preferred mode of dispute resolution. What is needed is to push mediation. And there are only two ways in which any state can flourish and take the lead and become the hub of mediation and set example. Firstly, that the state high court has to take the initiative and must support the cause of mediation, which I'm glad that step has been taken here. The second is the quality of the mediators, which is extremely essential because merely referring matters to people who are not adequately and properly trained is going to defeat the purpose. As a lawyer, when I used to do mediation cases, and I used to see the mediator not prepared, not having basic understanding of the process, I lost faith in mediation. And every time I would tell my client, it's just a mere formality. It's a delaying tactic. Never believed in the process unless I myself got trained. So training is essential. It makes you the expert of the process because you are all already trained in many different fields, and already you are doing everything that, probably in terms of knowledge, I'm sure you are the best of the minds the country has. But so far the process of mediation is concerned and the sensitization, I'm only going to delve into that in the short time that I have been given. And I assure you I'll not exceed my time. I want to touch upon the why of mediation, because unless we believe in it, and if I'm not able to demonstrate to you why you should push mediation and how it is effective, I don't think you will be convinced to take that extra effort to look into a case and refer it for mediation. Because the mindset of a judge is that I have to deal with a case. Either I can spend my energy in adjudicating it or convincing the party to go for mediation. But why that extra effort of pushing mediation is important, and why there is a debate all over the country whether mediation should be mandatory or not. And why are we only restricting ourselves to 12A? Why are we not looking at every case because Section 89 empowers. Honorable Justice Ravindran's judgment in AFCON has given teeth to mediation. It says that you must send parties to mediation. In every case, wherever it is possible, as long as the judge is convinced that this matter has an element that it can be resolved by mediation, they must refer. Now the question comes, why should I propose mediation and why all of you should push it? My question is, and I would appreciate if the participants interact and give answers, I'll be grateful. We have to ask, each one of us should ask this question to ourselves. Is there a court in this entire world that can address emotions of a human being? Is there any court in the world which can heal emotions of a human being, is my question. Is there anybody in the participants who feel that yes, courts can heal emotions of a human being? The answer is no. And my request is, if anybody can volunteer and tell me the difference, because Lordship touched upon conflict. How many times in courts you hear people saying that X party is in conflict with Y party? I've never heard. We have only heard the word dispute. But why is it that courts are not talking about the conflict? And many students who are law students here, please tell me if you are taught any subject which deals with conflict, or where you have been trained about the conflict cycle, you have been told what conflict is. So that brings me to my next question. Can anybody in this room tell me the difference between a dispute and a conflict? We deal with conflicts all our lives. We are lawyers, judges. But do we really know what is the difference between a conflict and a dispute? Anybody would like to volunteer? See, the idea of mediation is to make it interactive, and because otherwise it gets a little long. So I'll tell you, conflict is the root of the matter, and dispute is only the visible part of the conflict. I prepared a PPT. I will just make you go through a document. Can we have the PPT, please? Can you look at that picture that I've just shown? What court deals with is merely the tip of the iceberg. What you see on top is the dispute. This is what parties project to the court in those files where black and white letters of law. They write what our story is, what is the law on the point, and what we want from court. But the why of the conflict, the why of the dispute is never there in those files, unfortunately. And there is no way any judge will be able to go behind it, because there's already so much of pendency. If every case we start digging and finding why parties are in a dispute. So it is only mediation where you actually start focusing on the conflict. Every mediation that I have done, I have never felt the need to even look at the files and the law, because the mediator's job is not to advise. Then what is the job of a mediator? Mediator's job is also not to suggest. Then I ask myself this question, then why is mediator there? The mediator's job is merely to facilitate the parties to arrive at an amicable settlement, to empower the parties, because it is their dispute. They should take ownership of their dispute and resolve it as per their terms. Because what happens in a court, nobody is listening to the parties. The lawyer is not ready to listen to because parties feel, if we start looking at the mindset of a litigant, the lawyer is really not bothered. Lawyer is saying, please don't tell me what to do. And in courts, they are not allowed to. Parties are hardly, in very few matters, they're allowed to speak. And for them, it may be a matter of life and death. So why not let them take control of their own dispute? Let them decide how they want to resolve it. But mediator will facilitate them, empower them. So mediation is nothing but facilitated negotiation. And the skill that is required is empathy and active listening. Because a mediator, unless you are able to step into the shoe of a litigant, you will really not feel what they're going through. We talk about sympathy, but empathy is something which is not discussed much. So if I discuss with you the difference between a conflict and a dispute, like I said, conflict is much larger and dispute is merely the visible part of a conflict. So courts can decide on a conflict, yes, no. The answer is that only a dispute which is there between parties can be looked into by the court. But when you win in a court of law, do you think you're actually winning? Winning in court of law is winning? I ask myself this question. If the relationships are over, if parties are not able to do business or work with each other again, how do we really say that parties are winning in courts when the relationship is over? So is there a way that we can figure out that where both parties can win? Why are we always trained about versus? When I look at those cases, A versus B, I grew up reading in books, Hadley versus Baxendale. Why there has to be a versus, even moot courts? Why do we have to train that one has to lose for the other party to win? Is there no way that both the parties can actually win? And that is only possible in mediation. I'll tell you how, because ma'am has already covered that what are the various causes why conflict is caused. Because unless we understand the psychology and the mindset of a disputant, resolving those disputes is almost impossible. Disputes may arise for various reasons. Firstly, the most common is unmet needs and wants. In every relationship that you see, even at home, somebody has some expectations from you. If those expectations are not met, it will lead to a conflict between two people. It may be difference in values of the parties. Everybody grew up in a different setting. We have different tradition, different culture. What may be, good for somebody may not be good for somebody else. So we have to respect the choices and the upbringing of each and every person. Assumptions, people draw assumptions and they never communicate. So lack of communication is another reason why conflict arises between individuals. Knowledge, somebody has given you knowledge about something, that can be a cause of dispute. Expectations, a wife having an expectation from husband that my husband should remember my birthday and give me a diamond necklace. But husband doesn't know. And wife presumes that he is supposed to know what I'm expecting. So only if these expectations are communicated, they can be met. Perceptions. What are perceptions? Perceptions are like tinted glasses that we wear, which are invisible. And they are made up of our childhood experiences, how we grew up, what all we saw. And that's how we look at things with those glasses. Now, conflicts are driven by two factors, essentially. Number one, how a party perceives a particular situation. And the second one is how they react to it. It is essential for us to understand that there are three general approaches to conflict. The first and the most common is the power approach. When a conflict comes to you, or when you are dealing with a conflict, you know that somebody is about to, your son comes to you and says something, I will not wear a helmet. You tell your son, I am telling you to wear the helmet, so you have to wear it. This is the power approach. That's how you are handling the conflict. The second is the rights approach. Telling him or her, the law requires you to wear a helmet, so you have to wear it. But the other party does not take it in a good light. So is there a way where we are able to explain in a way that actually serves the purpose and does not give rise to any conflict and ends it then and there? That approach is the interest approach. you have to show the other person their interest. If you say, I want you to wear the helmet because I care for you, it is for your own safety. The moment a party see its interest, that's when they understand better, and that really resolves the conflict and does not escalate the tension. That is what mediation is all about, moving parties from their position to their interest. When they come to the court in front of you, day and night, you must be seeing cases. Parties take strong positions. They never focus on their interest, even though they know that the adjudication may not be in the best interest of the company or the family. But how many times are we able to shift their focus from their positions to interest? So mediation is nothing but shifting the focus and mindset of parties from their positions to show them their interest. Last week, I settled a mediation between a husband and wife. Took me 3 months. Matter was going in court for almost 4 years. FIRs filed, divorce petition, the RCR, NCLT case for operation mismanagement. Matter was referred. 3 months, matter resolved. When they came to me, they were aggressive, fighting with each other. They couldn't sit in the same room. Amounts in dispute, 750 crores. One daughter. When they came to me for the first time, the perception was operation mismanagement. She is not managing. She has committed a fraud. FIR is filed. The wife comes with a different story. My lawyer has told me I will get 75% if I give the divorce. Husband says my lawyer has told me 7% is what they will get, and that too after 10 years. How do you bridge the gap of 7 and 75? They had taken positions. But after a month, it took me a month to find out what is their actual interest. They project the dispute to be completely different, but the reality was completely different. For the mother, the interest was the daughter to secure her future, her marriage, her education. She knew that she will need funds for that. For the father, the company was dying. He wanted to do work. That's how I was able to move them to 65%. And the matter got settled. Mediation, there was a very interesting story in one training I heard, especially in Indian tradition. Two brothers in a royal family were fighting with each other. I think more than a decade, the matters went on in court. The mediator somehow felt court had appointed a mediator thinking there is some element and this can be settled, because courts will find it difficult to divide. In this case that I'm telling, there were 134 properties to be divided. How do you divide? How do you do justice? And sometimes there are situations where it's impossible for the courts by application of law to do justice. And in that matter, the mediator simply asked the younger brother one question. Why are you guys fighting? He said, you ask the elder brother. He calls the elder brother. Elder brother says he doesn't respect me. After the father's death, I took care of him like my son, but he doesn't respect me. Then he sent him outside and said, send the younger brother. He asked the younger brother one question, forget about the dispute. Do you respect your brother? He said, of course I respect him. He's like a father figure to me. But what does that have to do with the dispute? He said, okay, if your elder brother walks in, can you touch his feet? He said, of course. I love him. He called the elder brother. The younger brother touched the feet. Guess what happened next? It may look a little dramatic, but they hugged each other, started crying. After half an hour, matter resolved. There is a need to Indianize mediation. Look at people like they're humans. For us, there may be just one of those cases that we are handling, but somebody, it may be a matter of life and death. And what is it that we have to do? We just have to give it a try. Send it for mediation, refer it for mediation. The trainings are undergoing. Lordship had mentioned in the morning that 900, or probably some of the, almost in every district now you have trained mediators. Give them the matters, give them work, be a part of the capacity building. And that's what you can do as your own. Each and every one of you has the responsibility to make a difference in life of hundreds and thousands of people. apart, I'm not going to say do it for reducing the pendency. It's not, the reason is it's a cause, because it's the ultimate way of resolving conflicts between individuals. They can work together, look at each other, and they can have a win-win situation. Look at this picture, for example. I hope you all can see. I'll not take much time. I know Jawad session is there. This is how perception is. Many a times we just look at truth the way we want to look at it. If you look at that picture, one person is saying there are 4 boxes, 4 wooden boxes. The other one is saying, no, there are 3. Now, which one is right? They're having a dispute about it. If you are standing on the left side, you are saying, no, it's 4. And no matter what, you will never try to understand what the other person is saying. Because we listen to respond, never to understand. And in day-to-day life, what we see in every relationship, even if we had done something wrong or we have argued with somebody, which can give rise to a conflict, you'll go back home. Before sleeping, it will come into your mind what happened. There'll be a proper cross-examination. There'll be a proper trial going on. I said this, I shouldn't have said it. No, but he said this. Ultimately, you are the judge, jury, and executioner, and you are never wrong. Perceptions are the real reason why we don't look at and we don't respect the opinion of the other person. That's what needs to be done, and it can only happen in mediation, because a mediator is able to see both the sides and understand where they are coming from. Look at this story. 6 blind men. These blind men were walking and they come across an elephant. One is touching the ears and is saying it's a fan. The other one, who's able to touch the feet, is calling it a tree. Somebody is calling a rope who touched the tail. Now, which one of these is wrong? Is any one of them wrong? But these are 6 different perspectives. Truth differs from place to place where you're standing. Not everything the way we see it is always right. But again, it is only possible in mediation that you can go into the why of things. What are the approaches to a conflict? This is a very important thing. I give a story to every training I go for. There's one very common story in mediation, which I am asking all of you. Suppose there is an orange at home. Today you go back and you see 2 of your siblings fighting over that one orange. How do you divide it? I'm sure there are many trained mediators here who must be knowing the answer to this question. Can you just raise hand, those who say that we'll divide it into 2 pieces and resolve the dispute? Just raise your hand if you will do this, please. Or anybody has a better answer? Nobody's raising hand. You have better solution? Yes. Okay, we have one hand. 2. Just raise your hand if you will just divide it into 2 pieces and... Okay, I see 5, 6 hands only. Okay, anybody wants to add something from the back? We have a mic. Because you need to participate. I really want to know if anybody has a better solution than this. Yes. That's correct. The answer is right. Normally, without the application of mind, what we do is, when they come to us, we say, okay, you keep 50-50. But this approach is called compromise. You have divided it. You have, for the moment, resolved the conflict. But our party is happy. The parties are not happy because they did not get 100% of what they wanted. If you look at this chart that I prepared, normally what happens is, when you step out of your house and you're driving in your car, somebody comes and brushes your car. What do? We stand outside our car, we fight with them for hours. But is it worth it? In such cases, it is actually the best thing to avoid. Avoidance is, I don't care. This is the first approach to any kind of conflict that you get into. I don't care. Leave it. I'm avoiding this. But that is possible only in short-term relationships, people you are meeting just for a day or just once in life. Somebody you have to live all your life or work with. Can we have the same approach of avoidance? The answer is no. We can't keep putting it under the carpet because one day there'll be an outburst and then there'll be no way to handle it. Then what is the other way? Other is, of course, competing, which we do every day. How parties look at it in a court, they compete with each other. I want to make sure that the other party loses, I will win. Competition. There's one approach which is vengeance, which I don't think I've mentioned here, where a party, and many times in courts, all of you must have seen that, I will drown, but I will take you with me. That is the worst. I will lose and you will also lose. And then there is accommodating. You go back home, your son wants to watch a cricket match and you want to see the news. You accommodate, you say, okay, you watch, no problem. But this accommodation is also not going to serve the purpose. So the only way in which you can ensure the interest of both the parties is taken care of is collaboration. Look at the chart of collaboration. The example that I gave you about the orange, rightly, one of the participants here has rightly mentioned, if you only asked them one question, why do you need it? And one of them would have said, I want to eat the fruit or make a juice. And the other one said, I just need the peel of the orange, maybe for a face pack or for any other reason. And dispute would have been resolved by giving them 100% of what they wanted. That is collaboration. We have so many learned judges present here. I have various other examples, but I have to restrict to some of them, but just two exercise for all of you. You see on that screen, body language, words, and paralinguistic. You understand better than anyone how important communication is. And communication is what the other person perceives and understands. It's not what you say. I always tell people, don't tell me what you said to them. Tell me what they understand. But I have to ask all of you, there are three ways in which people communicate. One is, of course, verbal. You say something, write something. That's the first form of communication. The second form of communication is body language, which is non-verbal. And then there is paraverbal, which is the tone, the demeanor in which it is said, isn't it? Now, what I want one or two of you to please tell us, when somebody comes to you and talks to you, or when you see people, if you have to divide in 100, how much weightage would you give to body language? How much weightage do you give to words? And how much weightage you give to the demeanor and tone in which it was said? Anybody? It's a simple question. Can you stand and answer? Sorry, I'm not able to locate. Somebody was saying, no, just give it a try. How you perceive it, that's all that's required. Verbal, you give weightage. How much out of 100? 70? 7%. Is there anybody who gives more weightage to verbal than 7? 55. Okay, anybody who gives weightage to the body language? 50%. Okay, and last question for demeanor. Is somebody here present who says demeanor and tone is most important? The way it is said. Excellent. 90%. See, in a room, in one state, we have learned judges present here. All of us have different way of receiving the communication. In front of you, we have 3 different sections. Somebody does not give weightage to words at all, what is being said, 7%. Somebody gives weightage to the tone, and somebody is only focusing on body language of the person. Let's look at what Professor Albert Mehrabian said. The result I'll show you. Can you see the screen now? Body language, 55%. It's a research. Body language is 55% for communication. If you read the body language of the person, the tone and tenor is 38%, the way in which it is said, and the words merely 7%. Many of us probably ignore the body language of an individual. So even when you sit as a mediator, your body language is also very important, because somebody who is emotionally charged, you have to build a rapport with them. Sometimes if you just sit like this, it communicates authority. It gives an impression to the other person. They don't feel comfortable, that you are closed. Somebody leaning back, putting the leg, may give a different perception. So the best body language that is said is called solar. SOLER is the term that they have used, is which I think Jawad sir will be covering. Now, just one last test, and I think then I'll call Jawad sir. We don't go so much deep into what parties say or somebody is trying to tell us. I'm going to tell you how every single thing that a person is saying, it can have 4 sides. Let us look at a basic example. You visit your mother after a long time, you go to your village, she meets you, and the first thing that she tells you is, "It's nice that you are here again." What do we understand from this? Anybody? Is it just a factual information, or there is more to it? That son is come. She's telling the son that you have come after a long time. Okay, that's one. Anything else that you can see in this one-line message? Love of mother, the relationship, absolutely. The pain of the mother. Come again and again. Excellent. So pretty much everybody has understood. See, but it's not always the case that we understand. Now look at this. What is she communicating? The factual information is, yes, your presence is nice. What is she revealing to herself in this message? I am lonely. She's lonely. And the relationship is, she's telling the relation, you don't visit me enough. Appeal is, there is an appeal also hidden in this. Please visit me more. So one message has an appeal, has emotions hidden, has a complaint also, and self-revelation. The reason why I'm getting too much into it is because mediation is, I think, it's an art, but I think it's also a science. And the training, the 5-day training, I know today we don't have much time, but I really urge and request each and every one of you to consider mediation as a tool, because the problem is, if you just use a hammer, then you'll just keep it. You're not using any other toolkit. In the toolkit, there are other options also. Mediation is a great tool which you have. But if you keep giving hammer to everybody, they'll just keep hammering the nail. There are better ways to resolve conflicts. There's a way to make this society a better place, to make a difference in life of others, and to promote the cause of peacekeeping and create more peacemakers. I have too much more to cover, but I know I'm running against the clock. There was so much more I wanted to share with you all. But if there are questions, I'll be happy to answer. But first, I'll request Jawad sir to come. Thank you very much. Thank you.
Good afternoon, everyone. It's always a problem, addressing a group in the afternoon, after lunch. मुझे हमेशा एक बहुत बुरा सपना आता है। जब भी मैं ऐसी किसी मीटिंग में बात करने जाता हूं तो मुझे एक बहुत I don't sleep the whole night. When I sleep, I get a nightmare. तो नाइटमेयर ऐसा होता है कि मैं स्टेज पे खड़ के मैं बक रहा हूँ और लोग सो रहे हैं आराम से। तो ये बहुत एक बहुत खौफनाक सपना आता है मुझे। तो इसीलिए मैं आपसे एक रिक्वेस्ट करना चाहता हूँ, क्या कैन यू ऑल स्टैंड अप इफ यू डोंट माइंड? And can all of you clap your hands? Please sit down. One thing that happened is I hear a lot of buzz around in the hall. It's a lovely auditorium. It's wonderful to be here. And Tariq and I are very grateful to the honorable judges and to the honorable Chief Justice for giving us this opportunity. The second thing is it also makes us feel good, because when you clap hands, though we asked you to clap hands, it was not spontaneous. You clapped hands because I asked you to. But I would like to believe that it is for us. Thank you so much. Yes, so friends, there are many judges here, I suppose. So I just want to ask a question, which is a question I very often ask judges. Okay, there are two parties before you. There is party A and there is party B. Now you're looking at party A and you're thinking, hey, this guy is right. You know, he's right. But when you look at the case, you feel you can't help party A. You can only help party B. Though, heart of hearts, you feel party B is not right. Have you come across such instances? Huh? How many of you have? Like, yes, you have come across. Yeah. So, what about the Honorable High Court judges? You have also come across many cases where you feel that party A is right, but you can't help him because the law says that, sorry, though he may be right, okay, morally or whatever, but legally, the other person is entitled to the relief, right? Many times we come across this. Now, how did we come to this situation? Because if you can just, again, I'm going to trouble you, okay? I'm not going to be easy on you like how Tariq was. Okay, you're going to hate me by the time end of this. But I just want you to, you have been given this spiral bound volume, yeah? Please look at page 64 of that. Please look at page 64. All of you have the page 64? No problem. I'll read out to you. Okay, now these are the words of Justice Krishna here. If you look at para 42, after the first part, 28 all rules of procedure are the handmaid of justice. He says, the mortality of justice at the hands of law troubles a judge's conscience and points an angry interrogation at the law reformer. Now, this is Justice Krishna here's English. So I think we'll have to translate into normal English. So basically what he says is, the mortality of justice means justice dies, and this is very troublesome for a judge's conscience, which is exactly what many of you answered me just before. You know, it is very troublesome for the judge's conscience and points an angry interrogation at the law reformer, because the law is something that may not be facilitating justice. Okay. Now he goes on to say the processual law, which is basically the procedural law in simple English, so dominates in certain systems as to overpower substantive rights and substantial justice. The humanist rule that procedure should be the handmaid, not the mistress of legal justice, compels consideration of vesting a residuary power in judges to act ex debito justite, where the tragic sequel otherwise would be wholly inequitable. Justice is the goal of jurisprudence, procedural as much as substantive. So what we find actually is, how did we come to pass? How did this situation come up? Because I think we need to, before we talk about mediation itself, which Tariq and even earlier the Honorable Chief Justice and Justice Vikram Nath also took us through all those things. So basically, we need to understand why this is necessary. Why do we need mediation? What is the jurisprudence of mediation? Is there a jurisprudence? Because we have a tendency to regard mediation as just something where you just make two parties sit and talk to them and tell them, hey, why don't you solve this because it's good for you? Is that all mediation is all about? Is mediation all about reducing the pendency of the courts, as Tariq rightly asked, right? Is that the only purpose of mediation? Or is there a jurisprudence underlying mediation? Is there something? Now, the court system that we have today, how did it evolve? From where did it come? Now, let's just look a little bit at that, okay? I'm sorry, this might be a little boring, okay? Because I remember when we studied jurisprudence, it was a long time back, about 35 years back when I was in law school. Jurisprudence was the most boring topic. And that was the time I had met my wife and I was dating her. So we used to sit outside and go exactly to mark our attendance. So basically, when you look at it from a jurisprudential perspective, is there a jurisprudence underlying mediation? It's a question that I have often asked myself. And what I thought was, okay, how were we delivering justice before we adopted the Anglo-Saxon jurisprudence? See, basically what we are having now today is the Anglo-Saxon jurisprudence, like what British colonial masters gave us. But before that, how did we decide? How did we resolve disputes? Much before that. We had a concept called dharma, right? Righteousness, equity. There are so many words that you can use to describe dharma. But the underlying foundation or the underlying basis for rendering justice was what was called as dharma. Now, if you just connect dharma to what the Greek and Roman Stoics talked about, Socrates, Plato, all these people, they spoke about the natural law theory. So the foundation of dharma and the natural law theory is very simple. Basically, human beings are good. Human beings like to live without conflict. They believe in harmony. They want peace of mind. So anything that gives you that is the law. But then that changed. Because what happened was, doctrinal religions came into existence. Now, Europe was overtaken by Christianity. And what Christianity basically said was that whatever God says is the law. Right? So righteousness, equity, all these things are not relevant. If God says this is the law, this is very well the law, right? Even if it leads to injustice or inequity or cruelty or whatever. So that was the understanding of the natural law. Natural law was understood as divine law. What God says is the law. Now, what happened? There was a problem between the church and the rulers at one point of time. We all know about the Church of England was started, and King Henry VIII had some problems with the church. So he broke away from the church. And that was also the period of the Renaissance. There was a whole lot of rethinking that was going on in Europe as to why should we follow the church. So therefore, there were different philosophers like Jeremy Bentham, John Austin, who came up with the concept of positive law. They said the person or the authority who should lay down the law should be the sovereign, the king, okay, or the ruler or the government. They should lay down the law and people should follow the law. Now, I don't want to go into the whole, the complex process of it, but what we do understand today is that human interactions, human relationships cannot be put in silos and say that this is right and this is wrong. It is much more complex than that. And one of the very important things that Tariq pointed out was that the underlying human emotions. How are we looking at this dispute? How are we looking at this conflict? What is our perception of it? Why is this conflict coming up? Why is the conflict coming up? Any idea? I mean, whatever explanation that you may have between two people, why is there conflict? Because the same situation, the two people are looking at it from different perspectives. So these perspectives are leading to a conflict situation. Now, while the law is very important, while the courts are very important, because somewhere along the line you have to define rights, you have to define what are obligations, rights, duties, because we are living as a society today, and society needs to be governed by laws. So while all that is there, and the courts intervene where there is oppression, there is cruelty, where there is injustice, the courts intervene there. But where human relationship is concerned, should there be another way of resolving the dispute? Like if I have a problem with my brother, should I take a gun and shoot him dead? Or should I sit and talk to him and try to find a solution for that? That's the simple question, okay? Now this is where mediation steps in, okay? So I'll just take you quickly into some PowerPoints that I have. Slide. Okay, I think the slides are not coming out. Now, what we have today, litigation is the most common. Of course, we also have arbitration. Now, the only difference between litigation and arbitration is litigation where the law says that this is the forum before you should vindicate your right. Arbitration says you can choose the forum. That's essentially the difference, okay? Now, let us see what is the status of the justice delivery system in our country. I'll just quickly take you through this. June 2023, you can, if these slides are not clear, perhaps you can just look at the spiral bound volume that has been given to you. First thing is the PPT there. June 2023, a 90-year-old man convicted for murder in a caste feud in 1981. January 2023, Calcutta High Court delivered judgment in a bank liquidation case filed in 1951. All the litigants had died. In August 2022, a UP Consumer Court awarded compensation to a train passenger for excess fare charged by the railways in 1999. In June 2023, the Supreme Court acquitted father and son after they had spent 25 years in jail, and the son had died in 2021. So today we have 14.2 judges per million population. Europe has 210 judges per million population, and US has 150. 25% of non-judicial appointments are still pending. Courts are understaffed. Procedural law continues from the British period. We upgrade our phones, we upgrade our computers, we upgrade so many things, our cars, everything, but our procedural laws stagnate, no upgradation. High courts take an average of 4 years and subordinate courts 9.5 years to dispose a case. Further appeals are not included. There are 5 crore cases pending in Indian courts. Now, if you ask me where I got all this information, it was sent to me from Ireland by a barrister friend of mine who had read it in one of the journals over there, okay, about the legal system in different parts of the world. So we have 1.45 crore cases, criminal cases of serious nature, murder, rape, armed robbery, theft, kidnapping, other violent crimes. 4.2 lakh cases pending for more than a decade, more than 10 years. 50 lakh cases more than 3 years. 1.82 lakh civil and criminal cases pending for 25 to 30 years. 69,000 cases pending in Supreme Court and 60 lakh cases in the 25 high courts. Now, as Tariq had already pointed out to you, Niti Aayog 2018 analysis says that it will take 324 years to clear this backlog, provided no new cases come. Now, here's the question. Tariq said, if the only tool you have in your hand is the hammer, every problem looks like a nail. So today, the only tool that we are using is litigation. Now, I would club litigation and arbitration together basically as adjudicatory mechanisms, where a neutral third person, either a judge or an arbitrator, sits and adjudicates the dispute, as opposed to negotiation or mediation, where basically parties sit across the table, negotiate with each other, and in a mediation, that negotiation is facilitated by a neutral third party. So the neutral third party has no decision-making power, cannot pass a decree or an award, simply has to facilitate the negotiation between the parties and find a solution. Now, most of the disputes, as we can see, apart from the fact that government is the biggest litigant and 50% of the cases are from the government, apart from that, if you look at the other interpersonal disputes, they are either contractual or arising out of legal relationships. Marriage, okay, within the same family, inheritance, business disputes, joint venture disputes. All these disputes are where there is a relationship between the parties. There's a legal relationship between the parties. Now, all these disputes are capable of being negotiated and settled. So you can negotiate and you can settle. Now, here's the challenge. Is it easy to negotiate and settle? You cannot. Simply because perceptions. Tariq pointed out that the way we look at things is different. He gave the very beautiful example of the 10 people who are, each one is perceiving the elephant in a different way. So negotiation, direct negotiation has its own challenges because you cannot directly negotiate because you're angry, you're upset, you identify the other person as the problem. The way you look at the problem is different from the way that person is looking at the problem. So all these challenges are there. So therefore, you need somebody to help you to navigate that process of negotiation, to take you through that process, to guide you, to take you to a situation where you're able to look at each other's perspective. That's the whole idea of mediation, to help people to look at each other's perspective, understand each other, realize that you are a victim of your own perceptions and you need to look at it from a different perspective. So essentially, what we are talking about is humanizing conflict, the human element of conflict. Because what happens in our legal system today, the moment a person, when you walk into a lawyer's office, you lose your identity and you lose control of the dispute. You have no control over it. Something may be very important for you, but the lawyer will tell you that, look, this is not what is going to cut ice in the court. Now, I'll give you an example of what happened about 20 years back. When I used to, just for survival, I used to do matrimonial cases also. Because matrimonial cases are, I really have a lot of admiration for lawyers who do deal with matrimonial cases. Because it needs a lot of, patience and a lot of attitudinal change that you need to develop. But I had this lady who came to me saying that I want a divorce from my husband. And I listened to her and I made my notes. And I told her, ma'am, come after 2 days. I'll have your petition ready. Now she comes after 2 days. She reads the petition and she starts crying. I got worried. I said, what happened? Why are you crying? She said, I didn't know that I had suffered so much. Okay. So basically what I did was she gave me some rice. I made biryani out of it. Why did I do that? Am I to be blamed for it? Am I at fault there? No. Because I had to bring all those facts into the framework of the law, which says that these are the grounds of cruelty. So unless I make out those grounds, I cannot establish the ground of cruelty and get her a divorce from the court. So I have to exaggerate. Okay, I have to, blow up certain things and make them sound really, really bad so that she's entitled to divorce. Now imagine this application goes into the hands of the husband. What the hell? What all she has said about me? He goes to his lawyer and the lawyer says that, don't worry, we'll also, file an equally strong objection. Oh, she had an affair with the neighbor and she was talking nicely to him. She doesn't talk nicely to me. So there is another story that gets cooked up over there. Now, this is what happens when you strictly apply the law. Now, basically, there's a problem between the couple. They are not able to live with each other. Now, how do we resolve that is something that needs to be discussed and a solution has to be found. So basically, the challenges of direct negotiation are high emotions. We have cognitive barriers. We have biases. I'm sure all of you would have heard of biases. All of us are victims of biases. Can anybody in this hall say, I'm free of all biases? I have no bias at all? You can raise your hand. Because if you raise your hand, I'm going to come and fall at your feet. Okay. Everybody has biases. And those biases are basically what we inherit from our parents, what we are taught by our teachers, what we learn from our environment as we are growing up. So we develop all these biases, okay? So we look at things from different perspectives. We have high expectations in relationships. So because of all these things, we are not able to directly negotiate, okay? Now, I'll just go back a little more into the history part of it because I think it's important to understand how this concept of mediation in the court, how courts started embracing mediation in the first instance, because mediation was there for a very long time. And even in our culture, we have several instances of, basically having a conversation, having a dialogue to resolve conflicts. We have had several examples like this. Our epics have a lot of such examples. I don't want to go into that now because there is a controversy as to whether Lord Krishna was a mediator or an ambassador. What was Lord Hanuman's role? All these things, let us not get into that. But all we understand now is that because Tariq pointed out that mediation is not just an art, it's also a science. It's a very scientific process because I'll be taking you quickly through the mediation process also. And Tariq, please tell me to shut up when I have to, okay? Because I like to go on talking. I've been a lawyer for 35 years. So friends, I love to talk. I love to hear my own voice. So please stop me if it gets too boring for you, okay? Now, what happened was in the US in the 1970s, a case which was filed in the court would take 11 years for the first appeal to be disposed of. So from the date of filing to the disposal of the first appeal. Now, that was also a very, tumultuous period for the US because they had, gone into the Vietnam War and people were generally frustrated with the government and with the courts. So there was a lot of frustration and disappointment all around, a feeling of unrest. Now, what happened was a global pound conference. I'm sure many of you would have heard about it. It is an annual conference that is held by the American Bar Association in honor of Roscoe Pound, a very well-known jurist. So this Pound conference took place and in 1977. And in this, Professor Frank Sanders of the Harvard Law University, he submitted a paper which he called as the multi-door courthouse concept. So what he said was, if a case comes to the court, it need not proceed to trial and adjudication. There should be other doors open for the parties to resolve. So one of those recommended methods was mediation. Now, at that point of time, there was the Chief Justice of the US Supreme Court was Warren Burger, and he liked this idea. And he said that we should start implementing it in the courts, and that's how it started getting implemented. Okay. So essentially, the idea was that what are called as rights in personam, which arise out of legal relationships between people and which can be solved through negotiation, should be referred to mediation. And rights where courts need to decide, rights in rem, where public rights are involved, those have to be decided by the courts. And even there, even the rights in rem, because government has always been the biggest litigant everywhere in the world. So they said that a lot of statutes, federal statutes, started having mandatory mediation clauses. So that was the change that happened, and that spread across the world. And today we see the growth of mediation in different parts of the world, where, for example, if you take Italy, for instance, they have what is called as the opt-out model. Initially, they brought in mandatory mediation. They said before you go to the court, you have to go for a session of mediation. But there was a procedural defect in passing that rule, so therefore that was struck down by the court, not because it was wrong, but because the procedural formalities were not complied with in passing the law. Thereafter, Italy came out with the opt-out model. They said at least one session of mediation you have to attend, and then you come to the court. Turkey has also adopted that. And in the US, one of the latest judgments, Churchill versus, I'll give you the full judgment. Okay, in fact, I wanted to circulate that also. It was in 2023 where the Court of Appeal decided that where any rule mandates pre-litigation mediation, because the CPR, the civil procedure rules there, mandate pre-litigation mediation. So you have to go for mediation is what the Court of Appeal has also held. So based on that, this concept of mediation in pending civil cases became very popular all over the world. And we embraced it a little late because though the 129th Law Commission and the Malimat Committee report recommended the use of mediation, it still took us some time. Section 89 was enacted in 1999, but it was notified only in 2002. And, it was, if you read it even today, it's very confusing because the court has to, if the court first has to see whether there are elements of settlement, then formulate the terms of settlement, then give it to the parties, get their feedback, reformulate the terms, and then refer it to arbitration, mediation, conciliation, blah, blah, blah. Now, the Supreme Court had an opportunity to look at this section and said that if this court is supposed to do all this, then why is the court referring it? The court has already done the job. Now, here's the challenge, because our legislatures are very famous for the cut and paste job. Because ever since Bill Gates brought in this Microsoft Word, the easiest thing to do is to cut and paste. And you see that, Section 73 from the Arbitration Conciliation Act was cut and paste here as Section 89 with a few modifications here and there, right? So this is Section 73. All these slides are there. I won't trouble you with that. Now, Salem Bar Advocates Bar Association case in 2003, Section 89 was challenged. It was challenged as being denial of access to justice. Supreme Court said that nothing doing. It very much amounts to access to justice. So therefore, you need to promote alternate dispute resolution and recommended that a committee be formed to implement, but nothing happened after that. And then we have this 2010 AFCON's case where Supreme Court reinterpreted Section 89 and said that, look, you don't have to do anything. The court simply has to see whether there are elements of settlement. And if there are, simply refer it to mediation. So referral to mediation was declared as mandatory. You have to refer it to either of the, not just mediation, either of the, alternate ADR mechanisms that are described in Section 89. But of course, mediation was the preferred mode. Mediation centers came up in different courts. And then now after 2010, the referrals started increasing because courts realized that, okay, there is some value in this, so let us refer it to mediation. And if the court does not refer to mediation, then the court has to record reasons for not referring. So that was the emphasis that was laid by the Supreme Court on mediation. Now, there were other statutes also, Section 4 of the Industrial Disputes Act, Legal Services Authorities Act, where local adalats were established, 442 of the Companies Act, Section 18 of the Micro, Small and Medium Enterprises Act, Section 32G of the Real Estate Regulation Act, 37 and 38 of the Consumer Protection Act 2019. All these legislations provided for referral to mediation. Now, 12A talks about pre-litigation mediation. Now, before the Mediation Act was passed. I can't say it has come into force because it is yet to be notified. So before the Mediation Act was passed, the only law perhaps which really mandated pre-litigation mediation was Section 12A of the Commercial Courts Act. Because the Commercial Courts Act was passed in 2015, but it was amended in 2018. And the Statement of Objects and Reasons very clearly says that commercial disputes need to be resolved very fast. And it's very important for India to figure high in the ease of doing business index. And therefore, there should be mechanisms by which these disputes can be resolved. Now, I just want to share with you something that happened many years back. I was advising a client of mine on a joint venture agreement that he was entering into with a US company. And the CEO of the US company had come to India. And we had lunch, and over the lunch, we were discussing about the ease of doing business. Okay, how easy it is to do business in India as compared to any other country. And he said that we prefer dealing with China. I said, China? I mean, just imagine a communist country and, all these issues are there. And how do you say that there's no proper system there? And our system is much closer to yours. We follow the Anglo-Saxon jurisprudence. And our courts follow the model of the English system. So why do you say China? He said in China, disputes get resolved in 3 months. Whereas I don't know in India whether it will take 30 years or 300 years. Those were his words. Okay. So this was the biggest challenge. So therefore, 12A is a very, very significant and very important provision of law that has been enacted. It has its drawbacks because it says where urgent interim order is not required, those cases have to go for mediation. Now, what happens if urgent interim orders are required? You have to go to the court. So the three important aspects are mediation will be attempted before a commercial suit is filed. Legal Services Authority will manage the mediation under the framework of the Commercial Courts Pre-Institution Mediation and Settlement Rules. Now, Mediation Act has brought about an amendment here. Apart from the Legal Services Authority, it can also be referred to mediation service providers who are registered who are notified by the central government. Now, exemption from mandatory pre-institution mediation in cases where an urgent interim relief is contemplated in a case. Now, tomorrow with the referral judges, we'll be dealing a little more in detail about this, Patel Automation Private Limited, where the Supreme Court held that you cannot bypass this. Unless urgent interim relief is required, you cannot bypass 12A, you have to go for mediation. And the court can suo moto invoke Order 7, Rule 11 to dismiss a suit if it is filed without complying with 12A. Okay, so they said that it is mandatory. Now let's look at the definition of mediation. Okay, I don't know how many of you are feeling bored now. You want to clap hands once again, or do we continue? No. Okay, no, I was just joking. So, definition of mediation. It's a voluntary process. Why should it be voluntary? Because parties have to decide the outcome, right? They have to enter into an agreement and they have to choose whether they want to go for mediation or not. Now, there is a big controversy about this. The law says mandatory mediation. Now, Supreme Court said 89 is mandatory. 12A says you have to go for mediation before you come to the court. Now, does it not conflict with the voluntariness of the mediation process? The simple analogy is taking the horse to the water. So the mandatory provisions simply say that take them to the mediation room. If they wish to, let them settle. If they don't, let them come back to court or let them go to the court. That is what it says. Now, I had a case where there was a landlord-tenant dispute that was referred to me. Now, I don't know what the landlord's lawyer had told him. The landlord just barged into the room, stood over me, pointed his finger at me and said, "Who are you? What power do you have? Why should I sit with you? Why should I sit with you and talk to you? It's a waste of time." I said, "My friend, would you like to sit down?" He sat down. And I said, here's the thing. Now, before you came here, who had the power to decide this? He said, the judge. I said, well, the judge has taken that power and given it to you and said, there is this fellow sitting here go to him. He will tell you how to use this power to find a solution for your dispute. So judge has given that power to you now to find a solution. Now it's your choice. You want to use that power or you want to go and give it back to the judge? It's your call. He quietly sat down, the mediation went on, and finally we settled it. So you see, people don't know. Many people don't know what are the advantages of mediation. Once they understand, voluntarily they take part. Because there are many cases which are referred by the court. So it is mandatory. So the courts refer. They come to the mediation room. They say, sorry, we are not interested. But you simply tell them that, look, why don't you just listen to what is all this about? And then make a choice. Because an informed choice is always better, right? You need to know. Without knowing, there's no point in walking away from here. So you explain to them the mediation process. Invariably, they sit down and take part in it, right? So the voluntariness starts from the time they come and sit there in the mediation room. Now they have a right to decide whether to settle it or not to settle it. Okay, it's a confidential process. Confidentiality is very important. Perhaps when we get an opportunity to do the training, we will look at the psychological aspect of this. Because there's a whole lot of neuroscience behind mediation. Friends, believe me, you'll be surprised how much of neuroscience you need to know in order to become an effective mediator. How people look at conflict, how the conflict affects them, what are the emotions, what is emotional intelligence, what kind of emotional intelligence or what kind of level of EQ is required of a mediator. So all these things are, a part of integral to the mediation training. Okay. So it's a confidential process because unless it is confidential, now believe me, you as a mediator are sitting there and you want them to share confidential information with you. Why should they? What audacity of yours to ask them to share confidential information? They wouldn't have told this information to their lawyers, certainly not to the judges. Now, why should they share that information with you? Because you have told them that whatever they discuss here is confidential. Okay? Without prejudice process, because it has to be without prejudice. Now, within 2 minutes, I'll finish the definition. We'll go for a tea break and then come back and briefly continue. Yeah. So all of you are welcome to get up at the stroke of 3. Okay, even if I'm continuing. Okay. So it's a without prejudice process in the sense that whatever happens in the mediation, if it reaches a settlement, if there is a settlement between the parties, the settlement agreement governs the relationship between them. If there is no settlement, they're back to square one. Nothing should happen to them that causes any damage or any harm to them. So that's the mediator's duty to make sure that it does not prejudice the rights of the parties. Where a neutral third party, obviously you have to be a neutral third party, right? Judges have to be neutral, arbitrators have to be neutral, so do mediators have to be neutral. Who has no decision-making power or a stake in the outcome, facilitates the negotiations. So the job of a mediator is merely facilitator of negotiation between the parties and assist them in reaching a mutually acceptable settlement. That's the only thing that a mediator does. So this is what is a very simple definition of mediation, where it takes into account all the essential attributes of the mediation process and defines what is mediation. So next, when we come back after tea, be prepared to see how the mediation process works, okay? Because I think it's important for us to understand that. Because many times we believe that it is just simply making two people sit and talk to each other. It's not so simple. It's a very nuanced, very scientific process, as Tariq has already pointed out to you. So thank you, friends. Let's have tea and come back. Thank you. Now, I think I think this came voluntarily, right?
Arrangement of the tea is for the district judges and all the participants is on second floor. For the dignitaries, it is at the third floor. The only thing that is required to be highlighted, I know anxiety is there for having the tea on account, is that this matrix of our conference involves all sorts of stakeholders, and therefore elementary level has been started to apprise all about what the concept of mediation is, how the same has evolved, what are the facets of it, and then to look at the statutory history of it. So it will be evolved and we'll be reaching to prims, the most important aspect.
She has repeated this number of times. Please, all my judicial brother and sisters, please come. પાછળથી, please.
આ બાજુથી please.
This side.
Ye- Now, please keep quiet. Now we are moving towards the last session, that is harmonizing arbitration and mediation, practicing exploring synergies and challenges. In this session, we are coming to know about the institutional mediation, mediation in arbitration, arbitration, mediation, and arbitration. So now I request the Honorable Resource Person, Mr. Tariq Khan, to address the August gathering. Thank you.
So welcome back. And thank you for your very active participation in the previous session. We'll continue from where we left off. So we saw the definition of mediation as being a voluntary, confidential, without prejudice process, where a neutral third party facilitates the negotiations between the disputing parties and tries to help them to reach an agreement that is workable for both of them. Now, why do we really need to mandate mediation? What is the scope of Section 12A is something that we need to focus on before we proceed to how the stages of mediation work out. Okay. Now, one of the most important judgments that we had recently on this is the judgment in Patil automation case. It is there in your, if you see page 51 of the book. Please just refer to page 57, where the extract of section 12A is given. I'll trouble you by reading the section, okay, because my senior used to say that if you want to argue on a particular section of law, provision of law, read it 10 times, then again read it another 10 times, again read it a further 10 times, and each time it will show you a new perspective, okay? So many of you would have read this, but again, I'm troubling you by reading this section. Pre-institution mediation and settlement. It's given at para 24 of the judgment itself. The whole provision has been extracted by the Honorable Supreme Court. Pre-institution mediation and settlement. A suit which does not contemplate any urgent interim relief under this Act. A suit which does not contemplate any urgent interim relief under this Act shall not be instituted, which means that a suit that contemplates an urgent interim relief need not go for pre-litigation mediation, because you need an urgent interim relief, therefore you have to go to the court. Shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by rules made by the central government. Now, of course, it further on goes to say that who are the authorities constituted under the Legal Services Authorities Act. Now the Mediation Act has amended that. If you look at the Mediation Act, it says that Legal Services Authority as well as any other mediation service provider that is notified by the central government. So earlier it was restricted only to the Legal Services Authority. Now you can even go to mediation service providers, which might be private institutions, which are offering mediation services, provided they are notified by the central government. Notwithstanding anything contained in the Legal Services Authorities Act, the authority authorized by the central government shall complete the process of mediation within, that's the time limit for the mediation. Now, what is very important is subsection 5, which says the settlement arrived at under this section shall have the same status and effect as if it is an arbitral award on agreed terms under subsection 4 of section 30 of the Arbitration and Conciliation Act. So the original section 12A prescribed that if you reach a settlement, pre-litigation mediation settlement, if you reach, because you're not before the court, under 89, what happens when a court refers the matter under 89 to mediation? It goes back to the court. Once the parties reach a settlement agreement, it goes back to the court and the court records that as a compromise, right? And passes a decree in terms of the compromise. But now this is the pre-litigation mediation, because before instituting the suit itself, you are going for mediation. So what should be the status of the settlement agreement? Now, what is the point if the settlement agreement is simply an agreement? If any party defaults, you have to again specifically enforce the agreement because you have to file a suit. Now that drives you into a whole new process altogether and defeating the very purpose of why pre-litigation mediation is prescribed. So therefore, this subsection says that it will be deemed to be an arbitral award on agreed terms. It's something very similar to the Arbitration and Conciliation Act, part 3, which speaks about the process of conciliation. But today, this section is also amended now. I think you have been given the Mediation Act also. So if you look at the Mediation Act, in one of the schedules, I think it's the 8th schedule if I'm not wrong. Ninth schedule, right? Thank you. In the 9th schedule, a mediated settlement agreement will come under section 27 of the Mediation Act. And what does section 27 say? It is enforceable like a decree of the court. So the provisions of Civil Procedure Code apply to that. Now from this, I think you can very well guess the importance of section 12A. Because one, you need to look at the statement of objects and reasons, which very clearly say that commercial disputes, because today India is opening up. It's a global economy now. Lot of overseas companies are investing in India. Now, for their investment to have some meaning, for disputes to get resolved quickly, it's very important that those disputes should be resolved very fast. That is the very objective of the Commercial Courts Act itself, to establish commercial courts which will follow a fast-track procedure. Now, even that procedure is not fast enough, so therefore you should go for mediation. That is what the intention of the legislature, that you can decipher from the objectives of these provisions which have been laid down. Now, at para 27, if you see, the statement of objects and reasons have been extracted. Now, this is the statement of objects and reasons of the amending act. 2015, the Commercial Courts Act was enacted. Subsequently, in 2019, it was amended to incorporate section 12A. So now if you see the objects of this, 2, 3, 4, and 5 generally talk about all those reasons why, 2, 3, and 4 talk about the reasons why this provision is being included. Now 5 says, clause 4, Roman letter 5 says, to provide for compulsory mediation before institution of a suit where no urgent interim relief is contemplated, and for this purpose to introduce the pre-institution mediation and settlement mechanism, and to enable the central government to authorize the authorities constituted under the Legal Services Authorities Act for this purpose. So these are the objectives that the bill seeks to achieve. Now, one of the challenges was implementation of section 12A. Now, what is the court's role? What should the commercial court do if a plaintiff bypasses this section 12A and straight away files a suit? Now, is it mandatory? Is it mandatory that parties have to go for pre-institutional mediation before invoking the jurisdiction of the court by filing a suit? Now, this was a question that was looming large. Now, there were two challenges in the implementation of the section, because we lawyers are very clever. We know how to draft plaints and we know how to craft interim reliefs, right? So with expert drafting, we are invariably circumventing this section because we make out a case that we need urgent interim relief. So the moment you say there's an urgent interim relief required, you are able to bypass this provision and file a suit directly. Now, this was a big challenge. Okay, so the section 12A was actually becoming odious. Like, it was of no use having that provision simply because people were bypassing it and filing. Now, the second drawback there was, now if you see the the civil commercial court rules for mediation, how do you refer parties to mediation? It says that you apply to the Legal Services Authority. Legal Services Authority will issue a notice to the defendant, asking them to take part in the mediation. Now, the defendant has The first option for the defendant is agree and take part in the mediation. The second option is refuse to take part in the mediation. The third option is simply keep quiet, right? You don't respond at all. Now, in all these three cases, again, no mediation, you come back to the court. Now, out of these two challenges, the first challenge was addressed by the Supreme Court when it dealt with this case, partial automation case, where the Supreme Court very categorically held that it is the mandatory provision. They analyzed, they compared it to section 80 of the Civil Procedure Code, where without notice to the government, you cannot file a suit against the government. They analyzed section 69 of the Partnership Act. Various provisions were analyzed, compared, and then they said that this is mandatory because it is not merely a procedural provision. It is a mandatory provision where you have to, because you will be defeating the objects and reasons for the act itself if you do not go for mediation. That was the finding given by the Supreme Court. But this judgment remained silent on the issue of urgent interim relief. Now, what happens if urgent interim relief is sought for by a plaintiff and the plaintiff bypasses section 12A and comes to the court? Now, what the Supreme Court said in partial automation case is that if you are not seeking an urgent interim relief and if you file a suit bypassing without going for pre-litigation mediation, then your suit can be suo motu dismissed by the court, invoking Order 7, Rule 11. The defendant does not have to come and say that, please dismiss the suit. You can outright, the judge can take a look at it, see that there's no urgent interim relief sought for, the plaintiff has not gone for mediation, invoke Order 7, Rule 11 and dismiss the suit. This is what Supreme Court said under partial automation case. They have said reject the plaint. Okay, they have not said return the plaint. Because again, returning will again be a procedural compliance. But there is a lot of sense in returning the plaint, telling them go for mediation. But the Supreme Court has said dismiss it under Order 7, Rule 11. Now, what they say is you can always, invoke, go for mediation and then come back to the court. So Order 7, Rule 11 will not bar a second suit if you have complied with the provision of 12A and you have not been able to reach a settlement. This is what Supreme Court has said. Okay. Now the challenge is, what about the urgent interim relief? Now, in case the plaintiff is seeking an urgent interim relief, even then should the plaintiff go for mediation? Now, that is the second case where Supreme Court decided that, and that second case, I think, is available at page. This is a fairly long judgment, partial automation case. I would urge all of you to read it if you have not read it already. Yamini Manohar versus TKD Kirti, that is there at page 84. I think in my humble opinion, Section 12A has been somewhat diluted by this judgment, but
after completion of
yes.
that particular request that you continue with the procedural aspect of the mediation that you have been going, and then sum up. That is what Chief Justice said. Tomorrow for local judges.
No, that is why I was. All right. So now, if you see this judgment, it says that it is only a suit where there is no urgent interim relief required. Only those suits you have to go for mandatory mediation. But if you don't have, if you have an urgent interim relief, you don't have to go for mediation. Basically, that's the essence of the judgment. I would just request you to read the last two paragraphs, which are very important. It would have been made us very happy if the Supreme Court had elaborated as to what happens if the court comes to a conclusion that the urgent interim relief sought for is an illusory one. Yes, but that has not been answered in this judgment, ma'am. But no, there again, 89 applies now. 89 CPC will apply because, yes. Yeah. If 12A goes, because 12A is only before the filing of the suit. Now, supposing if you have an urgent interim relief, you can always, court can invoke section 89 and refer parties to mediation. Now, I would just want to read this last two paragraphs. We are of the opinion that when a plaint is filed under the Commercial Courts Act with the prayer for an urgent interim relief, the commercial court should examine the nature and the subject matter of the suit, the cause of action, and the prayer for interim relief. The prayer for urgent interim relief should not be a disguise or mask to wriggle out of and get over section 12A of the CC Act. So my reading of this paragraph is that what the Supreme Court says without saying is that if the urgent interim relief is an illusory one, then partial automation case applies. So the court will have to dismiss it. Now, there are cases where the court may grant urgent interim relief immediately on the asking of the plaintiff as an ex parte order, ad interim injunction or whatever, or the court may order notice to the defendant and then hear the defendant and pass interim orders. Now, in either of these cases, a case is made out for urgent interim relief. But where it is only illusory, where it is disguised to just, get out of the provision, my understanding of this paragraph of the Supreme Court is that partial automation case will be applicable on all fours if you're not invoking. So therefore, we can understand from a reading of these two judgments how important this section 12A is and what the role of the referral judges when it comes to the implementation of section 12A. Now we'll deal with this in more detail tomorrow, because that is exclusively, tomorrow's session is exclusively for referral judges. So we'll be talking about what the role of referral judges is in such cases and what is expected out of you. So we'll go into more detail in these judgments and analyze this. Okay, now coming back to the process of mediation. Now what we saw earlier was that why mediation? Okay, because as Tariq also pointed out when he spoke, there is, beyond the dispute, there is a conflict. So the dispute is only emblematic of an underlying conflict. Okay, now the Second World War was a conflict. Now there were numerous battles that were fought. Those are the disputes. So there might be an issue of between two neighbors. It might be jealousy. It might be the fact that the other neighbor has a bigger car or the other neighbor has a more beautiful wife. There may be so many reasons for the jealousy, but the dispute is that fellow is dumping garbage in front of my house. Okay, but there is an underlying conflict there. Now, many times we are not looking beyond the dispute. We are not looking at the underlying conflict. So basically, it is the difference between what Ayurveda does and what allopathy does. Now, I don't want to walk Baba Ramdev's path and face any contempt proceedings, but all I'm trying to say is that basically it goes to the, in litigation, we are addressing only the dispute. But there is an underlying conflict there. Are we addressing that conflict? Because when we are talking about a holistic resolution of conflict, then we need to look at the conflict also and see whether that can be addressed. So how do we structure the process in order to be able to get through the parties, earn their trust and confidence, and get them to share what is most important for them, what their underlying fears and concerns are, and address those fears and concerns and their underlying interests. Now, Tariq was talking to you about a case that he recently settled. Now, apparently, the position of the parties when they came for mediation was oppression and mismanagement. Then one interest was unraveled. Correct me if I'm wrong, Tariq, because that was your case. I'm just explaining how this went on from what I discussed with him. So underlying that was something more. Security of the daughter. That was one of the concerns. Now, even beyond that, there was one more underlying interest that if I settle this today, my husband will get married to the woman he's having an affair with. So I don't want to settle. Now, that is the underlying interest. So if it's like the peeling of the onion. I think that slide you didn't show, right? In his PowerPoint, there is a slide. It's like peeling the onion. As you keep on peeling, layers upon layers come out, and finally you get to the core. So what is the essence of the dispute? Now, how do we do that? Now, before that, you can just have a look at this. I don't want to trouble you by going through this slide because it's essentially about the difference between litigation, arbitration, and mediation. So one fundamental difference that we need to keep in mind is these two, litigation and arbitration, are adjudicatory processes. So where a neutral third party is judging the issue and giving a binding judgment or award. But in mediation, it is a collaborative process where there is no finding or no judgment that is given by the neutral third party who's called as the mediator. Now, keeping that fundamental difference in mind, if you read this, it will be very clear. Now, when you're talking about doing all these things, getting confidential information, exploring the fears and concerns, going into the underlying issues and interests, how do you do that? What kind of skills are required from you as a mediator? The first and fundamental skill is people skills, because you're going to be handling people. Real, living, feeling people who come with the whole baggage of emotions, who come with the whole baggage of frustrations, disappointments, anger. All these emotions are there. So how are you going to deal with them? And more important, how are you going to deal with yourself? Because even as you're sitting through this, listening to the parties, you have your own biases. I was very happy when none of you raised your hands when I said, how many of you are without any bias at all? But we do believe sometimes in the, I used to believe that I'm a man without biases and prejudices. But I realized once I became conscious of the fact that we all have cognitive biases, it was a journey of self-discovery when I found that I have so many biases, right? All of us have. So how do you deal with those biases? How do you deal with your own emotions? I was mediating a case between husband and wife. And, the girl was so sweet, so nice. And this guy had placed cameras in the living room because he was suspicious of her. So all these things were happening. And all the time I had to be neutral. I had to keep a deadpan face. I could not show that, And the mediation center had sent one intern to observe mediation because they were doing a course on mediation. So they sent an intern to observe the mediation. And after the parties left, she asked me, sir, how could you not just get up and hug that girl and say, baby, don't worry, I'm there for you? I wanted to do that, she said. My heart was going out to her because it was such a pathetic case where this girl has suffered so much with this fellow. But how could you be, without expressing anything? I said, the moment I do that, he will make me a correspondent, right? So, see, these are some of the challenges that we face as mediators. Now, how far are you going to control your emotions? So, there's something called emotional intelligence, which is one of the skills that mediators need to develop. And that is part of the people skills. And we'll be going a little more into what are the people skills that you need. Basically, communication skills. Tariq pointed out that in his presentation, how important these communication skills are. And how, when people are speaking to you, the words may not convey the entire message. The words carry a lot of value, no doubt about it. But they don't convey the entire message. There is something called the tonality. Now, if someone were to call me, hey, you fool, I'll get angry because it's the tone of voice. Now, if somebody says, hey, you fool, I may not get angry because the words are the same, but the tone of voice is different. Now, the accompanying facial expression, how it works, all these things are taught to mediators when they undergo the mediation training. Okay. Now, what are the process skills? How do you structure the process in order to move from those positions that the parties come with, deal with their emotions, get their confidential information, earn their trust and confidence, and move them into identifying their interests, and then work at discovering solutions? Now, how do you structure this process? Tariq pointed out that it's a very scientific process. Yes, it is, because it is designed around neuroscience of how the human mind works. And when you get trained as a mediator, you get to learn which part of the brain gets affected when you're emotional? Which part of the brain is triggering those emotions? What is causing that? What kind of physiological changes are happening in you as you are going through those emotions? Now, all these things you get to understand, because structuring the process becomes very important. Now, the third thing is problem-solving skills, because we all have the habit of thinking within the box. We don't think out of the box. Now, lateral thinking. Now, for example, I'll just give you an example, okay? Now, I was mediating a case where it was a commercial dispute, essentially, where the German company had supplied some, leather processing materials and chemicals to an Indian company. Now, the Indian company was bankrupt. Okay, they were doing very well, but they were bankrupt now. And it was a very closely held private limited company with this man as the managing director, his wife and son as the other two directors and shareholders. Now, that was referred to mediation. And in the mediation, the plaintiff company realized that even if they get a decree, they're not going to be able to recover any money because there is nothing. Against what? Because, in our legal circles, we have this common saying that the problems of the decree holder start from the day he gets his decree in his hands, right? That's the start of all the problems. Because how are you going to recover the money? So they realized that it's only going to be a paper decree. Now, what happened in this mediation was, as we were talking to this man, we came to know that he had been the president of the Council for Leather Exports for a consecutive period of 3 years. And he was on first name basis with almost all the major leather manufacturers and tanners in India. The moment the German company came to know, they said, here's what we propose. We will appoint you as a distributor. So you get us orders, and we will, from your commission, we will keep deducting monthly a certain amount till our dues are settled. And then after that, we continue with the distributorship. We pay you your commission, full commission, whatever is due to you. Now you see the kind of innovative solution that came out of the mediation process, because people were willing to think out of the box. It was not just that I need the money, I recover the money. So give me a decree. Now when they realized that it is not going to happen, now they started thinking. Now this is what the mediation process does. So problem-solving skills. How do you solve the problem? Now here is what the biggest challenge that we are facing today. How is our legal law school curriculum designed? What are we taught as lawyers? We are trained to become problem inflamers. I'm sorry to say this. I'm a lawyer myself. But we are trained to become problem inflamers. We are basically trained as gladiators. Now, in those good old medieval days, when people had a dispute, you would have seen in some English movies and all that, they challenge each other to a duel. So they go to a common public place and they fight it out with swords. So the swords clash, and whoever wins is the person who's right. So might is right. That's how that, I think probably that phrase came into being. Today, that's exactly what we are doing. Now, instead of using swords, we use words. So it's just an anagram, like you take the S from the beginning and put it at the end. So we are using words today. But effectively, what we are doing is we are not solving the problem. We are only inflaming the problem, and that's what we are getting trained in. We are getting trained only in adversarial dispute resolution. Where is problem solving being taught to us? Our clients are not interested in the judicial precedents. They are not interested in the nuances of the law. They want solutions to their problems. Are we able to provide those solutions? Now, I'm mediating a case. It's an online mediation that's going on. A young lawyer is appearing for the plaintiff. And he goes on arguing with me, saying that this is what the law says. This is what the law says. So I told him very politely, I said, please talk to your client. Does he want a decree or does he want a solution? And then you come back, I said. So he went back, spoke to his client, and came back and said, my client wants a solution. Then I said, can we work towards that now? And we have started discussing what are the different ways of solving the problem. So we are not taught any problem-solving skills. Now, this is where problem-solving becomes very important and integral for a mediator, because you need to start thinking out of the box, not within the box. We have a legal framework, and we tend to think within that legal framework. We try to find solutions within that legal framework. Now we need to step out of it. Mediation operates under the shadow of the law. You cannot have an agreement that is void under the law. You need to have a legally enforceable agreement, but at the same time, you can work out that legally enforceable agreement in innovative and creative ways, like how the German company and the Indian company did. So there are different ways of finding those solutions. So this is what we are talking about when we talk about problem-solving skills. Now, basically, people's skills are understanding the conflict. Where is that conflict coming from? What is driving it? How the parties are looking at it? What are they feeling about it? Right? How are they looking at the whole conflict? Because that becomes very important. Their perspective, how are they looking at it? See, how many times I have been practicing for 35 years as a lawyer. And I'm sorry that, till now I have never seen a fully satisfied client. They win the case, but they're not happy because that's not what they wanted. Because the law says something else and what they want is something else. And they get the relief according to the law, which is not what they want. So, understanding the conflict becomes very essential. How are they looking at it? What are they feeling about it? Now, when we talk about dispute resolution or conflict resolution, we talk about what is called as the satisfaction triangle. Please make a note of this if you can. There are three kinds of satisfaction that any conflict resolution mechanism should provide to the parties. Number one, procedural satisfaction. Now, invariably, our procedures are designed to give that satisfaction to parties because whether you see Civil Procedure Code, Evidence Act, all these talk about how to invoke the jurisdiction of the courts, how to apply to the courts, what process to follow. So therefore, there is an element of satisfaction because equal opportunity is given to both parties. The second satisfaction is the substantive satisfaction. What am I getting out of this? What is the outcome of this dispute resolution mechanism? Now, if you see what happens in the courts or in an adjudicatory process, one party wins, the other party loses, invariably. Or both parties lose. That's why we have cross appeals. Sometimes, even a party who wins is not happy. So substantive satisfaction becomes rather illusory. People may be satisfied, may not be satisfied. Now, what is most important is the emotional satisfaction, which is something that we really don't bother in an adjudicatory process because we are only concerned about facts and law. Now, what are facts? Facts is not the truth. Let us understand that. If we are kidding ourselves and thinking that facts are the truth, sorry, no. Facts are what can be proved before the court. If you can prove that the crow is white, that's a fact. If you can prove that the sun rises in the west, that's a fact, according to the law, right? So whatever you're able to prove before the court is the fact. So we are only concerned about facts and law. Feelings don't figure anywhere there. But then the reality is, these are people. These are living, breathing, feeling people. And they have a problem. And that problem needs to be solved in a way that they understand it. And that is where Amartya Sen's book, I don't know, Idea of Justice, how many of you have read? I'm still trying to read it. But certain things that I try to figure out from there, he talks about the concept of niti and nyaya. Okay, these are two beautiful Sanskrit terms. I don't think there's an equivalent of that anywhere else. Okay, niti and nyaya. So niti is institutionalized justice. Justice through the institutions. Now here's what happens in this niti. At the ground level, there may not be a satisfaction because it doesn't translate as complete justice. Justice according to law may not translate as complete justice. Now, complete justice is nyaya, where I feel that justice has been done to me. Now, how do you assure this? How do you see? It's not in every case that you can provide this. Believe me, I'm not saying that if any of you feel that I'm saying that courts should be shut down, no. The courts have a very significant and very crucial role to play in our society. They're there to uphold our fundamental rights. They are there to uphold the constitutional principles. They are there to uphold the state and to hold the state in check. There's a paramount role that the courts play, a very significant role that the courts play. But when it comes to ordinary disputes between people, why should the courts waste their time in deciding how much share should go to whom, how the divorce should happen, or to whom the child should go to? Why should the courts be forced to do this? And that is where we have 5 crore pending cases. We are a 1.4 billion people. So when you look at all this overall picture, where is that satisfaction? So therefore, this understanding the conflict, emotional intelligence, and communication skills. The process skills is basically how do you structure the process? We'll be going into more detail about this, gathering the information, facilitating the communication, developing the agenda, identifying what are the issues that need to be resolved between the parties. Now, these issues may not just be legal issues or factual issues, they might be emotional issues. Would an apology help to resolve this? That might be an issue. The question of trust might be an issue between the parties. How do you establish the trust and rapport between the parties? Now, all these issues need to be addressed. Dealing with impasse. When parties are reaching a situation where they're not able to proceed further, how do you deal with that? What techniques do you use? Now, all these things we come under the process skills. Now, next is problem solving skills. How do you facilitate the negotiation? As I told you, lateral thinking, thinking out of the box, brainstorming options. Okay, expanding the pie. How do you add value? How do you create more value? Now, what we saw in that German company's case was there was a creation of value there. Because here was a company that was bankrupt, on the verge of being wound up. Now, this company got a new lease of life, right? There was a value addition. And the other company had to recover the money. And they had now a good way of recovering the money by helping this company to establish. Now, here's what happened in another case. It was an arbitration. In an ongoing arbitration, the arbitrator referred the parties to mediation. And in the mediation, what happened? Now, this is a confidential process. The arbitrator does not know what happened in the mediation. Okay. Now, what happened in the mediation was the claimant was demanding 20 crores as a final, last, full and final settlement from the respondent. Now, the respondent said, I don't have the money, but here's what I'll do. I'm giving you a business proposal that's worth 5 crores. If you accept this proposal, you can earn 5 crores. Now, that company rejected that. There was no settlement. I had to send it back to the learned arbitrator. I get a phone call 3 months later from the claimant's counsel saying that Jawad, an award was passed for 4 crores. I think we should have accepted the offer. Right? So there's total uncertainty. You don't know how the court or the arbitrator is going to decide. Right? So today you have control over the process. And this is what I keep telling the parties. I tell them it's a voluntary process. You can walk out of it anytime. But here's what I say, that today you're in a seat of power. You have the power in your hands to resolve your dispute in the manner suited to you best. If you walk out of here, you lose the power. Right? So generating offers. Okay, we always have this habit of focusing on only one solution. Now, what we do in mediation is we get trained to generate multiple options. We don't, a party is, let's say, offering, I'm willing to pay 10 lakhs to the other party. I don't go to the other party and say, this party is willing to pay 10 lakhs. Are you accepting it? The other party says no. I come back to this party and this party says, that's the only thing I can do. I'm sorry. How dare he reject my offer? It collapses. So what we do is we sit with each party and encourage them to come up with multiple options. Okay? If this doesn't work, what else will? If this doesn't work, what else will? And then we test those offers. Okay? So testing the offers becomes important. Is this going to be acceptable to the other party? Put yourself in the other party's shoes and look at this offer. How would you look at it if this was offered to you? Is there anything better that you can do? Something that will work for both of you? So you start building that spirit of collaboration between both parties, right? And you encourage them to look at each other's point of view and try to come up with solutions that work for both. Exchanging offers. Can you imagine how challenging that can be? If you go and tell one party that the other party is offering you this, who the hell is he to give me this? I reject this. I'm not accepting it at all. Now, how do you convey the offer? And in a direct negotiation, that's one of the biggest challenges. Why negotiations fail? I was mediating a case where 8.5 crores was the claim. And the offer from the other side was 25 lakhs. And you know how much they settled it for? 66.5 lakhs. It was settled. Now, how did that happen? Because there was no meeting point. They had several rounds of negotiations that failed, but it came to mediation and it worked because I kept pushing each party to, improve the offer, and I kept, going from one party to the other. At one point, I brought both of them together. Then the magic happened. They started seeing the effort that each one, the sincerity of the other person in settling. They saw that. And when they realized that each one was sincere in settling it, they were able to come to a settlement. So this is what exchanging offers becomes a very critical technique in mediation. Now, this is, how the process of mediation works. This is just a sort of an acronym which Professor Joseph Stolberg has given. Begin the discussion, accumulate the information, develop agenda and discussion strategies, generate movement and options, escape to private sessions from confrontational meetings, resolve the dispute. Now, this will be very confusing if you just look at it like that. So I just want to go to the actual stages. Now, the first stage is convening. Now, in court annex mediation, convening is not relevant because courts are referring parties to mediation. But in private mediations, convening becomes very important in the sense that basically that's the first part of the discussion that takes place between the mediator and the parties, where you discuss the most important thing, the mediator's fees. Then you also discuss, who will bear the costs, where the mediation will take place, who will take part in the mediation. Now, all these discussions, many times it happens across emails, over the phone. You may not meet the parties, but all these discussions happen. Then you get into an agreement to mediate. Now, the Mediation Act talks about mediation agreement. And it says mediation agreement shall be in writing. Now, of course, the subsequent provisions contradict that. But we'll not go into that now. But from a very practical perspective, in a private mediation, it's very important to have a mediation agreement, an agreement to mediate, because it spells out the boundaries, the contours within which the mediation is going to work, how it is going to work. It informs the parties. Now, the second part of it is, did I jump? Welcome and introduction. So you're meeting the parties in person or online, where you welcome them, you introduce yourself, you introduce the parties, then the mediator's opening statement. Now, the mediator's opening statement is a very, very critical part of the mediation process. Now, many trained mediators don't understand the importance of this opening statement, because this is where you inform the parties about how the mediation process works. Virtually, you define the mediation process to them. Though all this might be there in the agreement to mediate, but the challenge here is, have they understood it in the right way? Because there is a difference. See, we lawyers thrive on interpreting what is written, either in the statute or in the agreement or in the pleadings. Now, if you can just write one sentence, I never sold that horse to you. If you can just write that down and see what you understand from that sentence, each time you will understand it in a different way. But when you're speaking, the meaning is very clear. Now, if I just write down that I never sold that horse to you, you may understand it as me not being the seller of the horse. Maybe Tariq sold the horse. You may understand it as it's not my business to sell horses. You may understand it as I did not sell the horse. Maybe the other person stole it from me, or I gave it as a gift. No consideration passed hands. Another meaning that might come is that particular horse was not sold, some other horse was sold. Maybe the horse itself was not sold, maybe a donkey was sold, right? So any meaning. Maybe the horse was not sold to you or somebody else. Now, when you're speaking, the meaning is very clear. When I say, I never sold that horse to you, I'm saying it wasn't me, it was somebody else. Maybe Tariq, maybe anybody else. I never sold that horse to you. It's not business to sell horses. Meaning changes. I never sold that horse to you. It's very clear to you that I didn't receive any consideration for it. I never sold that horse to you. I sold you a black horse. Now you're showing me a white horse. I never sold that horse to you. I sold you a cow or a buffalo or a donkey or whatever, but not a horse. Or maybe a bicycle also, right? I never sold that horse to you. I sold it to somebody else. So the meaning changes completely, right? So the opening statement plays a very significant role in telling the parties as to what they can expect in the mediation process and how it's going to work. Now, there's one more aspect of the opening statement, which when you undergo the training, we can explain that because it takes a long time, from the neuroscience perspective. Because because there's a particular part of our brain called the amygdala, which is the storehouse of all the emotions. And whenever you're emotional, understand that it is the amygdala telling you to be emotional. Okay, so it is the storehouse of all the emotions. Now, how do you calm down the amygdala? Because when they're coming into the mediation, they are in a conflict situation. They have fear, they have anger, they have disgust, they have frustration. How do you calm that down? And how do you move them into, how do you earn their trust? Because there are two kinds of trust when we talk about the mediation process. We talk about strategic trust. Now, what is strategic trust? A client comes to you trusting you as a professional, right? That is strategic trust. Now, supposing I'm boarding a flight, I don't check the pilot's license and try to find out his antecedents and all that. I simply trust and I walk into the flight. Now, if that very same pilot were to be holding the rope and I'm hanging from the edge of the cliff, would I trust him the same way? I won't. But if it was my brother or my sister or my wife or somebody else who's holding the rope, I know that even if their hands get cut, they will not let go of the rope. That is emotional trust. So now in a mediation, we are talking about how parties move from that strategic trust into emotional trust. Now I had a very, it was a very touching case for me because I was doing this mediation. It was a dispute regarding the custody of a child, and this girl had to abandon her 8-month-old child and had to flee from her matrimonial home because of the ill treatment that she was suffering there. Then she comes back and asks for the custody of the child. Now, what is important is, as I was having a private session with her and talking to her about what happened, she asked her lady lawyer to step out of the room. And then she discussed some very intimate details of her married life with me. And I was so moved by that, I asked her that, have you discussed this with anybody else? And she said, not even with my mother. I said, then how did you discuss this with me? She said, I knew that you will not judge me. And I knew that you won't tell anybody. Okay, so that is the emotional trust. Okay, so how do you move parties from that? Because why else would they share confidential information with you? They wouldn't have discussed this with their lawyers. She didn't want a lawyer to be there, a lady lawyer. She asked her to step out. So this is the kind of trust we are talking about. Okay, so parties' opening statement. Then you listen to the parties or their counsel. And basically, that is the position statement. What is their position? Where the dispute stands today? What is the actual dispute between them? So you listen to that, and then you get into the gathering information. Now, this gathering information is it's also called the exploration stage, where you're exploring with the parties, not only the facts, but also the feelings. So you're empathetically listening to them, you're using some active listening skills, you're using some reflective listening skills, and you're listening to what they have to say, trying to understand not just the facts, but also the feelings. So when you exit this stage, when you go to the next stage of setting the agenda, there should be clarity in your mind that this is what is important for the parties. And these are their fears, these are their concerns, these are the aspects on which they need a resolution. So that clarity should be there. So it takes a long time. The stage takes a long time. Then once you set the agenda, what is it that we need to resolve? What is it that we are going to be discussing about? What is it that we are going to be negotiating about? So these are the issues. So you check with the parties that, okay, this is what we are going to be talking about. And then you take them into the negotiation. And this is where you facilitate the negotiation. You encourage them to come up with multiple offers. You test those offers. Then you check with them, can this offer be conveyed? And then you convey the offer to the other party. Now this goes on. It's a kind of a shuttle. The mediator keeps shuttling between one party and the other. Now, if the parties are comfortable to discuss or negotiate with each other in the presence of each other, then you basically brainstorm options. Now, there are many techniques of doing this, which are usually taught when you're basically getting trained as mediators. The next is closing. So either you have an agreement, or you have a partial agreement, or you don't have an agreement. So how do you close that? So this is basically, the slides are there. I won't trouble you with this. So what I have already explained to you is already there. Okay. So parties opening statement, accumulate information, developing the agenda, negotiation, and testing of offers and proposals, because you don't simply take an offer and go to the other party without testing it. Oh, I'm willing to say sorry to the other person. And you happily go to the other person and say, oh, this person is willing to say sorry to you. And that person will say, I want him to come to Gujarat High Court, stand in the middle of the High Court, fall at my feet, and say, I'm sorry. And you go back to the other party and say, this is what that party wants. Who the hell said that? I just said, I'll say sorry. What is this? So test the offer. Okay. I'm willing to offer 10 crores to the other party. That's very good. But where is the money going to come from? Right? So how are you going to arrange the money? Is it realistic? So you test the offers. Closing, settlement, agreement reached, partial agreement, no agreement. Now, agreement should be very specific. Normally, there's a saying that if an ordinary man or woman gives an orange to another ordinary man or woman, they will say, here, take this orange. But if a lawyer is giving that orange, the lawyer is going to say, I, so-and-so, son of so-and-so, residing at so-and-so, do hereby transfer, convey, and grant unto you all that right, title, and interest, blah, 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 in the orange. So it will go on. So a mediated settlement agreement need not be so complex. It has to be, as far as possible, in the parties' words, the way they understand it. You check with the parties and you get them to sign it. Now, there is a contradiction between what the Mediation Act says and what 12A says on whether the mediator should sign the agreement or not sign the agreement. The Mediation Act says mediator only authenticates the agreement. But 12A says the mediator signs the agreement. Now, this is something that the courts will ultimately have to resolve. What is the role of the mediator? So it should always contain a default clause. So this is what basically you do. And we come to the end. These are the stages of mediation. So basically the stages of mediation, just to summarize, the mediator's opening statement, where you set the stage, you explain to the parties, you help them to understand what the process is all about. You, address all their fears and concerns by giving them that, because the sense of autonomy, that they can walk out. Imagine that freedom to walk out. That makes them sit. Okay, it works the other way around. If you tell them you have to take part in the process, they're not going to be happy. But if you tell them that you have the freedom to walk out, that becomes an empowering thing for them, because that you're respecting their autonomy. When you tell them it is confidential, you're assuring them that no harm is going to come to them. So that opening statement becomes very important. And then the party's opening statement, then the gathering information, where facts, feelings, fears, concerns, all this is understood by the mediator. So it happens in private sessions, joint sessions. And then you come to a stage where you set the agenda. These are the issues that are concerning you, and this is what we need to negotiate on, facilitate the negotiation, help them to generate multiple offers, test those offers, and finally reach an agreement. Okay. So that is the end of the stages of mediation. So we would welcome any questions. You will come. Okay. Okay. Now, Tariq will be talking to you about the hybrid processes that we follow sometimes. Come. Thank you. Thank you.
Can I get a hand mic? I'll use a hand mic. I'll take the liberty to use the hand mic. The last session and not a lot of time. I have to run against the clock. I'm reminded of Johnson's letter to Boswell, wherein he said that, I'm sorry for writing a long letter to you because I don't have the time to write a short one. So the difficult task always is to put something in brief, in brevity, when you have very limited time. But I'll just cover briefly. I understand we all have had a very long day. I'll just take the mic. Okay. So, thank you. See, we have discussed mediation today, and I just want to briefly touch upon MEDAR, our MEDAR. And when I started today, the discussion about mediation, I did touch upon the aspects relating to emotions, conflict, etc. And I think we have delved into that at length. But before I start ARB, MEDARB, and MEDARB very briefly, because these are the most recent concepts across the globe. And the latest one in Singapore, which I saw in the convention week last year, is LIT, MED, LIT. Why these concepts are coming, I'll briefly come to that. But I'll just touch upon the brief history of arbitration. How many of you know that what was the first arbitration law in India? Is there anybody in this room who can answer? Which was the first act of arbitration in India? It was 1899. Arbitration started in 1899 in India, but that act was extended only to 3 presidency towns: Madras, Bombay, and Calcutta. But arbitration is not a new concept. If you look at the international history, I remember one conference which I attended long back. Gary Bond was there, and Justice Nariman was there. That's when I got to know for the first time that as per the biblical theory, King Solomon was the first arbitrator. That famous story where 2 mothers were fighting over one baby, and the King Solomon said, okay, I'll divide the baby into 2. I'll cut it into 2 pieces. The real mother said, no, don't do that. Let her take it. So that was the first case of arbitration. And there have been in Greece also, we have heard, island of Salamis, and there were Spartan judges who were all arbitrators. But in India, it started in 1899. Then we had second schedule to CPC, which was completely dedicated to arbitration. But in 1940, a need was felt, and the law was brought in, which was completely dedicated to arbitration, a proper law. And 1908, second schedule of CPC was repealed. The law of 1899 was also done away with. In the morning, I mentioned, I'll again repeat those words. Those are very important. What Justice D.A. Desai said, the name of the case is Guru Nanak Foundation versus Ratan Singh. On 29 September 1981, he said, and I'm again repeating at the cost of repetition, interminable, time-consuming, and expensive court procedures impelled jurists to explore alternate to the court system, and that led them to the Arbitration Act of 1940. However, in the way in which the scheme of the act has been implemented, and without any exceptions, the awards are challenged in the court of law, has made lawyers laugh and legal philosophers weep. This is where we have come from. So arbitration essentially was brought in to help the court system as an alternative. Today, Lordship rightly mentioned in the morning that arbitration has now become a mirror image of litigation. Now we need mediation to help arbitration. But in many cases, you see the issue that mediation is facing is the legitimacy some places and enforcement in a lot of places, and the trust relating to the process. But arbitration has already picked up, has become the preferred mode of dispute resolution. In the morning, Lordship also mentioned that even at the stage of Section 11, there are a couple of disputes which, if referred to arbitration, may end up being very expensive for the parties. For example, MSME disputes. Under the MSMED Act of 2006, there is a provision, Section 18, which is a very interesting provision which talks about 2-tier mechanism for resolving disputes. Firstly, there is a mandatory conciliation. So no matter what the dispute is, if you are a registered entity, that is a micro or a small enterprise under 2N of the Act, you will first have to mandatorily do conciliation. If conciliation fails, the matter is then referred to arbitration. Now, let me tell you that after the Mediation Act of 2023, one thing we all need to understand and to be on the same page is that mediation and conciliation are now same. India is one of the only countries probably, or maybe one of the few countries which treated mediation and conciliation as separate for the longest time. But the Act of 2023 has done away with that difference. So from today onwards, we must understand that conciliation and mediation are one. So why I'm giving reference of MSMED Act is it worked wonders. And my book on MSMED Act, I've covered it extensively. What is the success rate? So only because there is a hybrid model of combining mediation with arbitration, we saw great results. Many matters never went to the court or to the arbitration. They got resolved in conciliation stage itself. The reason why MSME is there, of course, because of the interest rate. 3 times the compounding rate is there if you don't pay on delayed payments. But that opportunity to go to mediation before going to arbitration has helped parties in arriving at a settlement. And that also gives them a clarity on their claims. Because when you sit across the table, and I'm telling you this with experience, what I have felt is parties are in a better position to know what claims they have, because if you don't negotiate and sit across the table, you will think I have 10 claims. But when you hear the other side in a mediation, now you know, no, only 3 of them are tenable. Then you'll be better prepared and you'll be able to identify the issues better, even if you have to go to dispute. So that negotiation will never go waste. And there have been cases where parties were in a mediation, and never ever should it be said that mediation has failed. Unfortunately, in many court orders I have seen, judges writing, the mediation has failed. Mediation never fails. At this juncture, parties could not arrive at a settlement. Because in many cases, you see 3 months later they settle, and then they come back. My plea to all of you present here today is, please never say that mediation has failed. The other thing is, MEDARB, like Lordship rightly pointed, it can be done if a matter is referred to the court. The court must exercise its mind. Should I give it a try and send it to mediation once? What is the harm? Notice is issued, give it a try. If they come back, appoint an arbitrator. But there's another interesting mechanism, which is now becoming the popular choice internationally, and that is ARB-MEDARB. Arbitrator is appointed. Arbitrator feels, because when arbitrator is sitting, again, arbitration has now become just like a mirror image of litigation. Just like we talk about court referring matters for mediation, similarly, an arbitrator should also exercise the mind and decide, can there be a mediation in this? When I sit as an arbitrator, at least in 2 cases, I have done that. But the question comes, can I be the mediator myself? Then I go back to Section 80 of Arbitration and Conciliation Act. Section 80 says that a conciliator cannot become an arbitrator. There's a clear bar. Why? The reasons are obvious. Because when parties are opening up, like Jawad sir was pointing, when they are sharing their emotions with you, they are being honest and there is a confidentiality attached, they overshare. And then you are the arbitrator. If it fails, then you will obviously be biased. Though my mentor, late Shri Fali Nariman, always took the view that I don't see any problem in that. He was one of the only persons I know in this world who used to advocate that no conciliator can become the arbitrator. That you need to have that in you. You need to be able to take care of these inherent biases and get rid of them when you are sitting as wearing a different hat. And that is the beauty of adult learning. Adult learning is unlearning. Anybody who's an arbitrator need not necessarily be a good mediator. And that's why a trainer of a mediation need not be a good mediator. So a lot of unlearning needs to be done and then relearning. The example, when somebody asked me, there was a training which I was taking, they said, why do we need to do a training? We already know the law. I said, just because you have been driving a car all your life, does that mean that you are ready for a Formula 1 race? There's a separate kind of training required for that. And you have to unlearn how you normally drive in a city. That's why these trainings are essential no matter where we are at what stage in our life. So the ARB-MEDARB model comes into picture, and Lordship had rightly mentioned in the morning, what do you do? How do you then exercise ARB-MEDARB? At the moment, that is the most successful model in the world. The idea is, let the arbitrator be appointed. Many of the participants today must be doing arbitrations. You don't decide because there is a prohibition in the law under Section 80. But under the MSMED Act, that prohibition is not there because MSMED Act prevails over Arbitration Act. So only in MSMED cases, the conciliator acts as an arbitrator, it's allowed. though I am somebody who's against that, that issue is pending in Supreme Court. But otherwise, the way law stands as of now, the conciliator cannot be the arbitrator. So what you do, Lordship mentioned that there is a center here in High Court. We have an arbitration center which is doing exceptionally well. Same set of arbitrators. Just in between those dates that we are giving, maybe 1 month later or 2 months, we may refer this to an independent mediator or have a panel of mediators in Gujarat High Court or the mediation center. And we say that we will try the ARB-MEDAR model. We'll try a mediation. If it comes back unsettled, we'll go ahead with the arbitration. But just in case, in some cases, if the dispute gets settled in mediation, then we bring it back to arbitration, and that settlement will become the consent award. ARB, MED, ARB. Why ARB, MED, ARB is required? Why can't it just be mediation? When Singapore International Mediation Center introduced the LIT, MED, LIT model, I asked them because I was curious, why is there a need to complicate and bring these kind of protocols? Why can't you simply have a mediation? They said the beauty of the process of mediation, which is confidentiality, parties being able to generate so many options, that is there. At the same time, the international recognition of a commercial court, which is the enforcement aspect, which mediation lacks, unfortunately, worldwide. That we are getting with this hybrid model. So therefore, LIT, MED, LIT. So my plea to all of you is to consider having a model of this kind. Try it, there is no harm. It's not that any delay is going to get caused. Lordship has, in fact, when I met Lordship for the first time, Lordship had indicated that this is something which is in her mind. And I think that if we are able to do this, you'll be the first state in the country doing it. Till now, I have not come across any state which is actually working on MEDAR model or ARB-MEDAR model. Lordship. Lordship, what the other centers are doing, if I may say. So what the other centers are doing, so normally how ARB-MEDAR, LIT, MED, LIT, and MEDAR work is that when parties are entering into a contract, they put a MEDAR clause, which means that first we will try mediation. So language of the clause will be, in case of any dispute arising between the parties, the matter shall be first resolved amicably between the parties. And if within 30 days or 60 days it is not settled, the matter shall then be referred for arbitration.
So that is multi-tier clause.
That is a multi-tiered clause. But in these multi-tiered clause, the first step becomes mediation. So maybe the matter goes to, because there is mediation and section 11 is filed, one party will say, my lords, this 11 is premature. They should have first gone to mediation. And in that sense, the matter is referred to the mediation center. And that step is being done, then they refer it to arbitration center. But what I am talking about is whether there is any such clause or not, the arbitrator on his or her own can refer that matter. What is stopping the arbitrator from doing that? Whether there is a multi-tiered clause or not. Because normally the clauses we deal with are only arbitration clause. This is something which is just a suggestion. Nothing is lost, but only if parties are able to arrive at a settlement. In fact, recently I met one of the retired judges. She's one of the finest mediators in Bombay. What she told me was very interesting. She said, I just tried mediation in a case, but after the arbitration. I said, how does that work? She said, see, I can't be a conciliator and arbitrator in the same matter. I passed the award, kept it in an envelope, came to the parties to pronounce it, and I kept it on the side. I said, today you are getting this award, but it's in a sealed cover. Now I want to try to negotiate and see if we can arrive at a settlement. Parties gave her the consent. They sat for 8 to 9 hours, and around 11:30 in the night, matter settled. She did not give the sealed cover to anybody. So it can work in whichever way, as long as the arbitrator also understands that our MEDAR model can work. But there needs to be some awareness. not every matter may be fit for it, but that's just something I think I wanted to point out. I know that some of you may have questions, and we've already about to exceed our time.
You were
Lordship.
right. I was a little bit confused. This model is nowhere.
Lordship.
This ARB MEDAB is nowhere.
In fact, when I met Lordship for the first time, I heard it for the first time that a court can also think in that direction. I never thought, because mostly I was listening to all this in London and Singapore. There, these models are there. But no Indian court till now, as per my knowledge, has implemented our MEDAR model. That they have a mediation center, they have an arbitration center. We will now collaborate between our centers. We will send matters from MEDARB center to MED to ARB and ARB MED ARB. This is something which is to be explored, some kind of protocol, if it can be designed, I think it can work wonders because, yes, sir. Yes, sir.
About that ARB model, how it evolved was that New York Convention was there. Now, when mediation started became a sort of a dispute resolution method that was acceptable for these cross-border disputes, the challenge there was the enforcement of the mediated settlement agreement.
Correct.
The Singapore Convention was not there, and the New York Convention required that the proceedings should have started in an arbitration for the award to be the settlement agreement to become enforceable. So therefore, the option that parties were using was they would invoke the arbitration,
Correct.
go for mediation,
Right.
come back, get an award on the basis of the settlement, and then go to execute that. But now with the Singapore Convention, that possibility, that requirement no longer exists.
I think that becomes a blessing in disguise.
Yes.
That-
If there are questions, you continue.
Okay, thank you, Tariq. So, any questions? I know, all of you are very tired. You've been sitting the whole day and listening to us. So if there are any questions, please feel free to ask. Yes? Yeah. Can you give the mic there, please? Would you mind standing up, gentlemen?
Jawahar sir,
Yeah.
You say that after the civil decree, the real difficulty was start
Yes.
for the education of the decree. So arbitrator award, it also same procedure
Same
before.
problem. Same problem.
He also come before the civil court.
Yes.
So it is also difficulty was start.
True, very true.
And
Very true.
second, my other question. As per CPC, indigent person can file the civil suit for the recovery and compensation also. In arbitration, any mechanism is available for the indigent person?
See, arbitration, we all know that it is strictly governed by the terms of the agreement between the parties. And the arbitrator is bound by the scope of reference to the arbitrator. So if any relief is sought for, that is either outside the scope of the contract or outside the scope of the reference, the arbitrator doesn't have any power. Okay, because the arbitrator is not acting ex debito justitiae like how a court does. So therefore, that cannot be done in an arbitration, which you can do in a suit. I hope that clarifies your question. And the first question that you asked me, you're absolutely right. Because see, again, these are adversarial processes. All adjudicatory processes are adversarial processes. So therefore, somebody suffering the decree or suffering the award will always seek to avoid that. So that is where the challenge comes. Look, how are you going to execute it? Now, the advantage with mediation is you have a settlement agreement with the consensus of both parties. So both of them are evaluating all the pros and cons and coming to an agreement that works for both of them. So therefore, the enforcement of that becomes much easier because parties invariably abide by the agreement that they have reached. It's only where, for some reason they are not able to, then the question of execution comes. Any other question? Yes. Yeah. Yes.
So I think section 27 or
27.
27.
27.
It says that it will be enforceable as a decree of the court.
Yes.
So then execution in civil court, you know the fate of the execution.
No, that is, see, the section 27 becomes applicable only where one of the parties commits a default or
Okay.
refuses to comply.
Right, right.
So
Huh.
only then,
This answers my query.
yeah. because-
Otherwise, if the.
Otherwise,
this-
it's parties
right.
are going to act by the agreement.
True,
Their agreement. It's not something that's imposed on them. It's something
Right.
that they have voluntarily done. So why
Right.
should they go back on it?
Got it.
Yeah.
Thank you.
Thank you. Yes.
Sir, maybe we can discuss it tomorrow, as you said,
Yeah.
as you have rightly said. Sir, you said if plaintiff does not contemplate any urgent interim relief,
Yes.
then it should be returned under Section 7, Order 7.
Order 7 rule.
As per the Supreme Court judgment, it has to
Yes.
be suo motu, plaintiff has to be rejected
Yeah.
under 711.
Yeah.
Sir, according to me, plaintiff can't be rejected under 710. Reason is because when you are returning the plaintiff has to be returned to the court which is having the jurisdiction.
Yes.
The mediation center or maybe the mediator, according to me, is not the court. Therefore, on this point, we'll deliberate. But according to me, an order under 710, a judge would not be in a position to pass. This
You're
is the only-
talking about 711 or 710?
I'm saying, sir, you said it
Yeah,
has to
order
be
7
rejected
rule.
under
Yes,
710.
Yes, yes. No,
I'm saying
711. Order 7, rule 11.
Yes, I'm
Rejects the
sorry,
complaint.
Order
Yeah,
7,
yeah.
Rule 10. You said it has to be returned under Order 7, Rule 10.
Rule 11.
That
Not
is
returned,
rejection.
rejected.
That is
See,
rejected.
Yeah, rejected. Rejection
Yes.
of the plea. Yeah.
Sir, sir, I'm sorry if I gathered the information wrong, but during the conversation, you have conveyed that it has to be returned under 7, Rule 10,
No, I
according
think
to
that
your
was-
opinion.
No, sir, I was, sorry if I don't
Jay.
know whether it was a slip of the tongue or not,
Jay.
but I thought I said Order 7, Rule 11.
Rule
Rejection.
11, that is fine.
Yeah,
That is fine.
rejected
That
order.
can be
Yeah,
done.
yeah.
711D, yes, good
No,
enough.
no, if I said Order 7, Rule 10, I stand corrected. It's
Order,
not that,
order,
yeah.
order. Thank you. Thank you.
Okay. Could be.
Good evening, sir.
No, maybe I was suffering from the same disability. Yes.
Sir, let me take you to the inception of Arbitration Act 1999. When it was came into existence, the basic intention behind taking into existence was to hasten the process of
Yeah.
justice.
Yeah.
Parties should reconcile that. At the time Arbitration Act was enacted, the same thing which you lectured today was was the intention of the legislature. But initially, as your ladyship has rightly stated, that each and every steps comes to the court, 8, 11, 34, 37, 17, etc. Now, sir, by putting these 27 in this Mediation Act, which is recently enacted, do you think that there should be some different kind of organization or different body should be there who can directly implement the execution of agreement? When you said that one of the party is going to disobey or broke the agreement, so this process can't be used to enlarge the life of litigation. Do you think that it will be misunderstood or miscarried? They
Sir, I think, see-
misadvantage, people can take misadvantage of this process. They can have a time in mediation process. They arrive at a conclusion. Then I don't follow, I don't obey. Now there is no liability or action against me prescribed in the Mediation Act. Then how it is going to fruitful? The same thing which Arbitration Act is suffering from, this will create the same position in future after 10 years.
No, you're absolutely right. See, one of the foremost things that is very important in a mediation process is good faith participation.
But sir, when two peoples have conflict,
Yeah, I
or
agree with
disputes,
you. No, that is right. You're absolutely right.
this is going to create a same. So what
Yeah.
this is my suggestion, that why strict compliance of that mediation agreement should not be complied.
See, that is where the act says that it will be enforceable like a decree of the court. Okay.
Yeah, but that is a
No, I agree with you. I got
Yeah.
your point. Your point is that again, if you have to go for the execution,
The
parties
same thing we are arrived.
parties can misuse. No, what you're suggesting is a very good suggestion, but unfortunately, that's for the legislature to take it up and do it. We can't do anything now. We have to go by the act.
Yeah.
Okay. So your suggestion is a good one. I really wish that the legislature would apply its mind to it and come up with a mechanism for enforcement. Yeah. Yes. I think it's off.
Then two parlance are very different, because arbitration is merely the agreement of the parties to litigate not into the court but beyond the court, before the third party. But mediation is the voluntariness of the party where they both are deciding for the settlement. So the situation are different. So the situation are different. That is the basic difference between arbitration and mediation.
Or sometime they ask the court, they request the court to send the matter to mediation just to avoid or delay the proceedings. That is also one of the feeling which people carry, and even parties carry, the lawyers carry the other side, that they are trying to avoid. And this is more happening in those matrimonial matters where husbands are, there are like maintenance is granted and then they are not complying with and they are avoiding. Or so this general feeling is there.
I think one of the
What he
reasons.
said is
Yeah, I
that
get
is
the-
because of that feeling.
Yeah. No, I get the feeling, ma'am. The first point is that if anything has to be abused or misused, people will find a way of doing it. That is number one. I don't think we can really find a solution to that unless people decide miraculously that we'll all act in good faith. That's number one. Number two is, that is why there is a time limit prescribed for mediation. Because as you rightly said, parties take advantage. So supposing it, we have seen in our High Court also, because portfolios change every 3 months. So sometimes what happens is they find an inconvenient judge who's not in favor. They say, please refer it to mediation. They come, 3 months go, then they go back to the court saying we are not settling. So there is an abuse of the process, no doubt about it. And it is bound to happen also. There's nothing we can do to stop that. The only thing is, statutorily, time limits are being prescribed. Now, under Section 89 itself, 60 days time plus 30 days is given. Normally, I think, universally that's being followed. Under the Mediation Act, 120 days plus another, I think, 60 days or something. So totally 180 days time is given. So within that time, they have to, otherwise it'll be sent back.
Just one more thing, ma'am, questions you asked. So when you read about the role of a referral judge, it's not just to refer matters, it is also to identify and do an assessment that what are the suitable cases. And there is no straight jacket formula to identify. A judge who's sitting as a referral judge has to see the position of the parties, their willingness, and whether it will be fruitful or not. And that's where a judgment has to be done. And that's why I think the training tomorrow will be about this. Not every case is fit for mediation. To give you an example, if, Lordship.
Yes, please.
To give you an example, I mean, we recently did an MOU with the state police, and they said that we'll send some matters, 498A, those, because there's a counseling that has to happen. They said, we'll give you that opportunity. We'll do it pro bono, I said. But in those cases, if suppose there is a case where there is a violence involved, husband beats the wife and she is facing violence at home, there's no point sending her back home or doing mediation in here. Such cases should not be referred to mediation. So that's a call a judge who's sitting as a referral judge has to decide whether one party, and as judges, you are in a better position than any one of us. And I think you can teach us as to where the moment party walks in, you know what is their intention, whether there's a delay tactic, etc.
You are right, but I think in tomorrow's session, you have to address that part, because sometimes referral judges are also in conflict. They are facing conflicting situations. And sometimes they have that gut feeling that if I am sending these parties to mediation, they may settle. But parties are not agreeing at that moment to go in for mediation. So then how can they address that? Sometimes what happens that as a referral judge, sometimes you have to push, you have to force the party. So whether they should do it or not, that is very, very important to understand.
So one of the things that we have been suggesting to our courts also is that when you're invoking your powers under Section 89 to refer the parties, it's always very helpful if both parties are called to the chamber and the judge briefly explains them that, look, these are the advantages. So I feel personally that this is a matter that is fit to be, mediated. So I'm referring you. And what happens is that sort of lays the foundation in the parties' minds as to what, because many times if you just simply refer them, they are confused. They don't know. They have come to the court. They expect an adjudication by the court. And now the court is sending them somewhere else. So they are wondering what is happening. They get confused.
Just one more thing in that. So that's why it's very important. That's where advocates play a very important role. And constant training for advocates is necessary because they are the ones who ultimately represent and convince parties. Parties always listen to the lawyers. Without the involvement of advocates, I don't think in any state mediation can flourish, especially the court annex mediation.
What
Yeah,
I'll
in fact, there
request
is
is that, what I'll request is that tomorrow, we can have,
Sorry, please.
we can continue with the advocates tomorrow. Tomorrow we have only a road for referral judges. We have said the advocates need not come, but can we include the advocates now?
It'll be good if they can.
Tomorrow, the advocates who are here can also come for the session, though it was restricted to referral judges. All of the advocates can also participate, who are come from the taluka also. They can stay back and participate in tomorrow's sessions also. That's a request.
Do you think, Tariq, that is needed? Presence of advocates
Lordship.
in this role of referral court judges is very, very important.
Lordship, their role is important in the sense that it's the lawyers sometimes who do not understand the potential and they resist when they're
So-
appearing before.
So I think I can issue a mandate that they have to be here.
Lordship, in fact, there is one thing which is happening across the.
And that is not coming from my side, that is coming from you.
Absolutely.
If the trainer says
No, even.
that they have to be here, then they have to be here.
No, because initially, Lordship, in fact, initially it was looked at that mediation is coming as something which is going to be a drop in revenue. That's why lawyers protested in Delhi and many other places. But today, lawyers are the ones making money when they are actually dealing in commercial disputes. It's a good revenue because these disputes which come in mediation also, the commercial disputes, they are high value disputes. And there is a specific training for that for advocates, which is advocacy in mediation, which is now coming up in a big way. I have undergone a training like that. Some of the trainers from Harvard were present, and it is fascinating what the role of a lawyer is in a mediation.
So I would request you to show that aspect to the lawyers to, so that they may understand that this is also one of the lucrative, can be one of the lucrative practice for them and getting lot of respect out of it.
Now, as a matter of fact, what Tariq mentioned as ADR being perceived as alarming drop in revenue by lawyers.
Right.
Now, here, there is again another Niti Aayog report, which I had read some time back. It was basically on the implementation of ODR, online dispute resolution, where they say that an estimated 75 to 97% of justiciable causes don't come to the courts. So what the lawyers, whatever we lawyers are living off is that 3 to 4% of the cases that are actually coming to court. Now, what is happening to the rest of the disputes? 75 to 97% according to Niti Aayog. They are either choosing to live with the conflict or they are going to some extrajudicial means like kangaroo courts, the local MLAs, the police stations to get those resolved. Now, if there is a legitimate way of resolving these disputes, this will be a huge revenue addition because lawyers will be expanding their portfolio by embracing mediation. That is how we see it as growing. Because this is what happened in the US. Because in the US, there was initially a protest from the lawyers. But when they started accepting it, now the American Bar Association has two sections. One is the mediation section and one is the litigation section. Now I'm told that the mediation section's annual conference is much, much larger than the litigation conference. So that is the extent of practice that lawyers have in mediation over there. Not all of them are mediators. They are mediation advocates representing parties in mediation. Because that itself requires a total change of thinking because you have to have a problem-solving approach over there, not an adversarial approach. So you have to work collaboratively with the other person, with the other side lawyer, and you have to try and find solutions that work for both sides.
In fact, just one thing, Lordship, the mediators, now after the law, what I'm seeing that in high commercial value dispute, some of the mediators are making more money than arbitrators also. So it's not that mediation is just going to be something which people are doing pro bono or as something which is a side thing. It is going to become a serious profession, just like people underestimated arbitration. And now people are doing full-time arbitrations. In times to come, we will see, because corporates don't want to go to the court. They like confidentiality and they want to resolve by negotiation. And now to the extent that trainings are happening for dispute avoidance, how to identify disputes early and rectify it. So identifying signs of early disputes and then fixing it.
I think there is a judgment passed by Justice Ravindra there. Even the parties are not ready for the settling in mediation. The judge has the discretion to send the matter to the mediation.
Yes, AFCON's judgment. Yes.
My question is where the pre-litigation mediation. Here, what has happened that since 2009, I'm working as a mediator in High Court. But when precisely I'm taking matrimonial matters, at that time, what has happened that there is a huge soreness between the parties. Even they are not ready to sit besides each other. So in that case, pre-litigation, what are the scope? Because in US and in other countries, there is a scope of mediation in pre-litigation stage. Here, after this act, Section 5 provides us pre-litigation. But what the judiciary and what we can do as a pre-litigation stage mediation?
One thing I'd like to add, and then I'll give to Jawad sir. See, role of advocates is very important. What we are seeing is mediators, judges. It is the advocates' party's trust. If the advocates will say, no, believe in this process, like I changed. Before the training, I never believed. And my client used to come, what is going to happen? Because client is hardly aware what is going to go on. So I used to say, this is just a waste of time. Don't listen to them. And then whatever the lawyer says, the party says the same thing. So we need to involve lawyers. Without their support, mediation in any state cannot flourish. And I have seen, and I was privileged because Justice Ravindran took me to the Bangalore Center. He said, I want you to see what is happening there. They have a proper, full-time, full-fledged, proper mediation center running. There is a cost list, hundreds of matter listed, and success rate is about 68, 70%. Same is in Delhi. Unless there are referrals, ADR will not succeed. The more the referrals, the more the result. So when in doubt, refer.
Now, the other point that you asked was, what about pre-litigation mediation? Now, that is where invariably what we have found in our experiences, the other party is always resisting mediation. That is where the convening part, I spoke about the first stage of mediation, the convening, that becomes very significant. Because that is where you interact with the other party and explain to the other party what are the advantages, and also that it's not going to hurt them in any way. It's a without prejudice process. So by participating, there is a possibility that they may resolve. If not, they are back to square one. So the issue comes only when they have to share the fees. Okay, so that is where the challenge comes. They say that why should we? Now, what happens? The party who seeks the mediation invariably agrees to pay the full fees. And there is an agreement. I did one case where they said we will meet the initial costs. And if the settlement is reached, the other party will bear their share of the cost. So that is how it worked out. So see, today the problem, Jyoti, is that we have a big challenge because people are not aware. And my experience has been that wherever you make them aware, they are willing to do it. Nobody wants to live in conflict. Okay, nobody wants conflict in their lives. Okay, they want peace. They want to go on with their lives. They want solutions to their problems. Today, there is no mechanism to provide that, and that is where mediation has to be popularized. It has to be propagated. And as Tariq said, the role of lawyers is very significant, very important in this.
We'll close this now. I think we have exceeded our time. We have just, unless there is any last question, I think we can close the session with. Okay. I think we can.
Thank you. Thank you, Honorable Mr. Jawad sir and Tariq sir, for highlighting the different aspects of the mediation as well as different section of the mediation. The object of the conference is to sensitize every stakeholder to understand what the mediation is and to implement the mediation in routine court proceedings. From the knowledgeable address of all the luminaries, we are able to learn that The mediation plays a crucial role in a resolving dispute efficiently and effectively. It is not the alternative mechanism, but it is the appropriate mechanism. Mike Jagger said that you cannot always get what you want, but if you try for something, you will find you get what you need. So that is the function of the mediation, and that is the role of the mediator. The mediation makes it happen. It make the party realize that what they need, not to pursue what they want. It further point out that the nominal winner in the litigation, often the real loser in terms of fees, expenses, and waste of time. With these basic keynotes, the conference will continue tomorrow for the referral judges and of course for the other honorable dignitaries also. Thank you very much. Thank you, Lordship.
Thank you, ma'am. With this, we come to end for the first day. Now, there is a request that tomorrow's session will start at 10 a.m. And as there is a request coming up from all the corners that many of the lawyers want to participate in tomorrow's session also. So it has been made out that all are requested to come. All must come, all judges and lawyers and mediators must come, and principal judges and principal family judges are requested to remain present. All others can move. Honorable, the Chief Justice is also desirous that since we are having this profound knowledge resource person, the benefit must be accorded to all the stakeholders on account. It has been complemented and all will be, all are invited tomorrow also, same at 10 a.m. it will start. And their stay and all arrangements have been taken care of. Thank you.
All PDJs are requested to stay back. The remaining participants can leave the hall, please. All PDJs will stay back. And family court judges. Principal judges, family court, and PDJs kindly stay back.